think we cannot hear anything, right?
Yeah, we are not able to listen anything.
I think it's on mute. Please unmute yourself.
Yeah.
And I think you need to unmute yourself. You're still on mute.
Okay.
Yes. Now it's better.
Now am I audible?
No, sir. Your sound, your visual is there, but sound is very slow, sir.
Okay. Now I'm audible now.
Yeah, yeah.
Yes.
Okay. Okay.
Much
Now
better.
let me introduce myself. I am a Rajinder Kumar. I am a practicing advocate in Supreme Court and High Court, and I am also an insolvency professional. I am a fellow member in CS and CMA. I am also an independent director. Now today's topic is managing hostile takeovers and the treatment of MSMEs under the IBC code. Okay, as all of us here are insolvency professionals, we are well aware of the practical challenges and legal complexities involved in managing hostile takeovers and the treatment of MSMEs under the IBC code. These are highly sensitive aspects of the resolution process and require strategic insight and a sound understanding of the law. There exists a significant body of on these issues. We will discuss case laws on this topic. Today we will explore this subject in depth. I have prepared a PPT and that I believe will assist in understanding how hostile takeovers are to be managed and how MSMEs are treated under IBC code and what the relevant judicial pronouncements, particularly those from the Honorable Supreme Court, High Court, NCLT and NCLAT. So let's begin today's session with the presentation. I will now share the PPT with you. Is PPT visible to everyone or not? Just a 1 minute. I think there is a problem. Just a 1 minute. Is this PPT visible to everyone?
Yes, sir.
Yes, sir.
Okay.
Yes.
Okay.
Yes, sir.
Okay.
Sir, but you start with F5. So, function key. So, we will see only the slides, not
Yes, yes,
the
yes. Yes, yes,
process.
yes, yes, yes. Okay. Actually, today's topic is managing hostile takeover and treatment of MSMEs under the IBC. Before the enactment of the IBC, the legal framework for handling distressed companies and MSMEs was fragmented and largely ineffective. Legislation such as the SIC 1985 were in place to address these concerns of SIC industrial units. However, the mechanism under SIC was slow and often failed to provide timely resolution on revival. Similarly, MSMEs were subject to multiple legislations like the Micro, Small and Medium Enterprise Development Act, which provided for recovery mechanism, but not comprehensive insolvency resolutions. The introduction of the IBC brought about the paradigm shift in the resolution process for MSME. Specific relaxations are introduced, most notably through Section 248, which provides exemption to MSMEs from certain disqualifications under Section 290 AC and H, allowing promoters of MSMEs to participate in the resolution process. These recognize the need to protect viable small business and ensure the continuity while preserving jobs and economic activities. So, and another is managing hostile takeover under IBC. Hostile takeover means in the context of the IBC, typically arisen when a resolution applicant propose a plan that is opposed by the maximum existing promoters or management, while the IBC is silent on the concept of hostile takeovers. The process itself enables market-driven solutions where any eligible resolution applicant can bid subject to compliance with Section 298. And there is a judicial decisions given by the Honorable Supreme Court on this issue, such as RSL Mittal India Private Limited versus Satish Gupta case and SR Steel have clarified that commercial wisdom of the COC prevailing in selecting the most viable solution plan, even if it results in a takeover against the wishes of the existing promoters. So there are so many judgments on these topics. We will discuss in detail these judgments so that we can understand how can we manage hostile takeovers under the IBC and what are the exemptions or benefits given given to MSMEs and how we treat MSMEs under the IBC code. Treatment of MSME under the IBC has been recognized as the backbone of the Indian economy, and the IBC acknowledges their unique nature. Through Section 248 introduced, the code allows certain relaxation to ensure promoters, MSMEs, and submit resolution plans, even if they were previously disqualified under Section under 298. The government has also enabled pre-packaged insolvency resolution process exclusively for MSMEs. The time is given here to resolve the CRP is very less, means as compared to 180 PRP is to complete it 120 days, in which provides a quicker, cost-effective and data in position model aimed at a minimizing disruptions. Courts have emphasized a balanced approach, protecting creditors' interests while ensuring viable MSMEs are not needless liquidity. There are so many cases also there. KK Agarwal versus Sanmati Metals and Ravi Mahajan versus RP MSMEs. Now first we understand कि
राजेंद्र जी, सर आपका
Yes.
स्लाइड मूव नहीं हो रहा है.
नहीं, अब स्लाइड मूव होगा.
ओके, थैंक यू.
Okay. First we need to understand what it means by the MSMEs. What is the criteria of MSMEs? What are the benefits given under the IBC code? And then we will discuss in the light of the judgments. Okay, what is the preamble of MSME? Where it is expedient to promote the growth and development of micro, small, and medium enterprises in order to enhancement entrepreneurial initiatives, generate employment opportunities, foster innovation, and contribute to the overall economic growth and the balanced regional development of the country. These are the preamble of the MSMEs, because MSMEs are very small enterprises. Government want to promote this sector. That's why there are some benefits given to MSMEs. For example, if MSMEs are business with any company, so there are some benefits. For example, the payment will be given to MSME industries within 45 days. It's mandatory. Otherwise, that payment will disallow the tax. So these are the benefits given to the MSMEs. First, we need to understand what is the MSME, what is the criteria of MSME.
My one question is there.
Yes.
If MSME make a claim or make complaint against the company under CIRP. So how to deal with them? Because the payment is to be made once it is received from COC or asset has been sold out. In between, he has lost claim. So how to deal with that?
We will discuss everything here in the light of the judgments. I will suggest request you to first I will go through all these things, then we will discuss everything, but I will give you a reply of your question. For example, in normal circumstances, every company will have to make the payment within 45 days. If MSME submit their claims, so then that claim will be as per the IBC code at the waterfall mechanism under section 53. So means in case of that company is in CIRP, so then payment will be given as per the resolution plan. In that case, that company will not be able to get in 45 days. And whereas the micro, small and medium enterprise sector plays a vital role in the industrialization, exports and poverty elevation by supporting the manufacturing and service sectors, and where as it is necessary to provide a legal framework for the classification, decision and promotion of MSMEs to facilitate access to credit technology, marketing and infrastructure, and where as it is essential to create an enabling environment for MSMEs by ensuring timely financial assistance, because MSMEs also struggle to get the finance. So that's why if any company falls in MSMEs, the company can get easily loan from the government because there are certain benefits given to the MSMEs. Therefore, this act or policy is enacted to recognize, regulate, the promote micro, small and medium enterprises for the advancement of the national economy. Introduction to MSMEs in India. India's economic landscape is significantly shaped by its micro, small and medium enterprises, which form the backbone of the nation's industrial development and the economic growth. These enterprises represent a diverse spectrum of the business, ranging from traditional village industries to modern small-scale units. Collectively, they contribute substantially to the country's industrial output, employment generation, and export earning. Because MSMEs are playing very crucial and important role in the economy of the India, because the more than 50% are contribution from MSMEs. Definition and classification of MSMEs. The conceptual framework of MSMEs in India has undergone significant transformation over the years, reflecting the changing economic landscape and evolving policy priorities. The Micro, Small and Medium Enterprises Act 2006 provides the legislative foundation for defining and classifying these enterprises. These comprehensive legislation mark the paradigm shift from the earlier focus solely on small-scale industries to a more inclusive approach that encompasses both the manufacturing and service sectors. See, now, what are the classification? As per revised classification criteria introduced in 2020, the government implemented the composite criteria based on the investment in plant and machinery, equipment and annual turnover. The modern approach represents a significant departure from the traditional investment-based classification system. The manufacturing and service sectors are now unified under common criteria, eliminating the earlier sector-specific definitions. In micro enterprises, these are the sectors or these are the companies are defined as those are the investment up to 1 crore and annual turnover not exceeding 5 crore. So these are the companies will be categorized under the micro enterprise. These enterprises are often represent family-run business and small manufacturing setups that form the grassroots of India's industrial ecosystem. In case, if investment is up to 10 crore and turnover is up to 50 crore, so these enterprise or companies covered under small enterprises. And what are the medium enterprises? Those companies having investment up to 50 crore and turnover up to 50 crore. So these are the companies and enterprises are covered under medium enterprises. and typically employ modern technology, maintain quality standards, and participate actively in global value chain. Because medium enterprises are those enterprises which are having investment up to 50 crores. So that's why they can also actively activate or do transaction and value add in the global value chains. We can also understand with the help of this. Okay, see here, what are the categories? There are three categories: micro, small, and medium. Investment limit. If there is an investment limit of 1 crore for plant and equipment, there is an investment limit of 1 crore. If any company invested, and turnover limit is less than 5 crore, so then it will be covered in micro. In small, up to 10 crore investment and up to 50 crore turnover. So these are the there are some amendments done in 2020 in MSME Act. So what are the recent amendments in MSME sectors in 2020 to 2025? So there are revised MSME classification effectively 1st July 2020, notification dated 26 June 2020. The most significant recent amendment came via notification issued under this MSME Act is this. They have done the categorize based on the investment and also based on the turnover. Now, unified criteria for both manufacturing and service enterprises. Turnover and investment linked to ITR and GST data populated in Uddham. Now, what is the major second recent amendment was that they have launched Uddham registration portal. Now all MSMEs have to update their data on the Uddham registration portal. So there are certain benefits to MSMEs when they are updating the data. So that data will be interlinked with tax department, GST department. When any MSME is going to update any or register GST data, so all the data will populate automatically. There was a mandatory online registration for MSMEs under Uddham portal. Integration with PAN and GST database, real-time enterprises classification, replace EM Part 1 and Part 2, and Udyog Aadhaar memorandum. So that was the second major amendment. I have already covered major amendments, okay, of the MSME sectors during this period. Inclusion of retail and wholesale traders, June 21. Retail and wholesale trader were included as MSMEs for the limited purpose of priority sector lending. These allowed this business to avail loans under MSMEs loans, but not other benefits like subsidies. So that was the third major amendments. Now, there was a fourth major amendments, raising of threshold for NPA classification. RBI increased our threshold for MSMEs accounts from 30 days to 90 days overdue for NPA classification. NPA classification has changed now from 30 days to 90 days. Under certain schemes offering relief in stress situations. Okay, raising of threshold for NPA classification, that amendment was introduced in 2023 by RBI. RBI increased the NPA classification from 30 to 90 days. Okay, there was another amendment under the Income Tax Act, financial year 2024, section 43BH inserted. Payment to MSMEs must be made within 45 days if agreement, or 15 days if no agreement, as deduction not allowed under income tax until payment is made. So that was the major amendment. Okay. Now we will understand in the light of the Supreme Court judgment on the MSME. Okay, there was a judgment given by Honorable Supreme Court in the case of Shriram EPC Limited versus Rayo Glass Solar SA in 2018. What was the judgment? Shriram EPC Limited versus Rayogulas Solar in 2018. What was the key issue? Because when we will discuss the judgments now, in the light of the judgment, we can understand easily how to manage or tackle the situation when there is a treatment of MSMEs under IBC, and also how hostile takeover is there. So then how can we manage? It is very easy to understand with the help of the judgments. Okay, now what was the key issue in this matter? The case dealt with the recovery of dues of by MSME under the MSME, focusing on the consequences of delayed payment by buyers. Facts. The applicant was a buyer who had delayed payment of Shriram EPC Limited, and MSME was a supplier. The MSC supplier filed a complaint before the MSME Facilitation Council for delayed payment along with a claim for interest on the delayed payment under the MSMED Act. Okay. So now, what was the Supreme Court's observation and ruling? Statutory obligation to pay within 45 days. The court emphasized that under Section 15 of the MSMED Act, buyers are mandated to make payment within 45 days from the date of acceptance or deemed acceptance of goods or services. Okay. So the means every company will have to make the payment within 45 days when they have acknowledged they have received the material and services. Okay, otherwise that if the company will not make the payment within 45 days, so then that this payment or this transaction will be also disallowed in the income tax, and also there is a interest and penalty payment. Interest for delayed payments. If payment is delayed beyond 45 days, interest must be paid to MSME suppliers at a rate of 3% per annum above the bank rate notified by the RBI. Okay. So means if payment is delayed beyond 45 days, that company will have to pay interest. What is the prevailing rate? Plus 3% per annum as notified by the RBI. The jurisdiction of MSMEs, the means MSMEs Facilitation Council has jurisdiction to adjudicate disputes concerning delayed payments and grant leave to MSMEs, including interest claims. No bar to recovery of interest. The court clarified that MSMEs can recover interest from delayed payments even if the principal amount is not disputed. So then, what was the nature of leave? The interest payable under the MSMEDs Act is a statutory right, not a contractual penalty, and must be strictly compiled with to protect MSEs. Significance: the judgment reinforced the protection mechanism for MSMEs against delayed payments. If undermined, the strict compliance buyer must follow regarding payment timelines, strengthened the role of facilitation centers as effective forms for speedy resolutions of MSME payment disputes. If there is a dispute in two companies, the MSME facilitation centers are helping to resolve these issues. Sent a strong message discouraging delay in payments to MSMEs, which are the critical for their cash flow and survival. Because if MSMEs companies, one part they struggle because they face some challenges to get means of finance or loan from government or another agencies, because they cannot arrange your finance easily. So that's why they have to face the problem of cash flow. If they will not get the payment or right time, so then they will not be able to survive. So that's why that act was introduced to protect MSMEs so that they can survive and they can easily get a loan from the government. And what are the legal safeguards for MSMEs under MSMEDC Act? Section 15, obligation to make payment, mandate payment timeline. Buyers are legally obligated to pay MSME suppliers within 45 days from the date of acceptance or deemed acceptance of goods and services. As per Section 15, there is obligation to make the payment to MSMEs within 45 days. deemed acceptance if the buyer doesn't communicate any objection about the goods and services within 15 days of the delivery. Acceptance is considered to have taken place automatically. If, for example, if any company means supplied material to MSME supplied material to any company, if there is any means issue with that delivery, with that means goods or services, so that company will have to communicate to the MSME companies within 15 days. If they are not acknowledging that, then it will be assumed they have accepted that material or product or services. So then they will bound to make the payment within 45 days to MSME company. So,
But what
and-
happened if the claim is against MSME itself undergoing CIRP? Then what?
pardon?
Because if MSME make a claim against MSME which is going under CIRP, because Section 238 is there, it is overriding.
In other judgment, I will discuss. Give me time. I will tell you. I will confirm you.
Okay.
Okay. Now Supreme Court judgment in Shriram EPC Limited. Written objection required. Any objection or claim about defects must be made in writing within 15 days. Failure to do same means the buyer cannot later dispute the quality of or delivery. Okay. Objective prevents buyers and unreasonably delaying payments by withholding acceptance. Okay. Now section 16 says interest on delayed payments. Okay. Buyers who delay payments beyond 45 days must pay compound interest at 3 times the RBI Bank of India bank rate, means 3% will be added on the unpaid amount automatically. Interest starting accruing automatically from the day after the due date without any need for formal demand or notice from the MSMEs. Okay. So now what was the purpose? The high interest rate penalizes delay and compensates MSMEs for the financial strain caused by the such delays, especially the impact on working capital. No demand notice needed. Eliminates the procedural delay by removing the requirement of MSMEs to send a payment demand before interest accrues. Okay, now as per section 17, recovery of dues. MSMEs Facilitation Council can approach the Facilitation Council for dispute resolution and recovery of delayed payment. Now, accessible form EFC provides a cost-effective and speedy alternative to regular courts designated for MSMEs limited resource. Okay, there is a recovery as a area of land revenue. The Act empowers the recovery of dues, principal plus interest as a area of land revenue, which is enforceable by the state machinery. Enforcement: the provision given MSME a strong legal mechanism to recover dues without lengthy litigation. Requirement: recover proceedings can commence after obtaining the necessary orders from the Facilitation Council. Okay, now the conclusion summary. MSMEs Act established strictly timelines and penalties to ensure MSMEs to get timely payments and powerful legal remedies to recover dues efficiently. These provisions address the key challenges of delayed payments that adversely affect the MSME's cash flow and business sustainability. The creation of the Facilitation Council and the power to recover dues as areas of land of revenue are particularly important tools empowering MSMEs to enforce their right efficiently. Okay. So this was the regarding of the, on the MSMEs. Now, next step is what is the treatment of MSMEs under IBC? Till this slide, we understood what is the MSMEs, what are the rule and regulations related to MSMEs. Now we will discuss what is the treatment of MSMEs under IBC code. Okay. Basically, our topic was the treatment of MSMEs under IBC code, and another was managing hostile takeovers under the IBC code. Now, IBC, Insolvency and Bankruptcy Code. Okay, first we understand now we know, everyone knows the preamble of IBC code, an act to consolidate and amend the laws relating to reorganization and insolvency resolution or of corporate person, partnership or individual in time bound manner for maximizing of value of the assets of such persons to promote entrepreneurship, availability of credit and balance the interest of the stakeholders, including a alternative in the order of priority of payment of government dues, and to establish an insolvency and bankruptcy board of India, and for matters connected therewith or incidental thereto. Key objectives. What are the key objectives? Time-bound resolution, maximization of asset value, promotion of entrepreneurship, enhancement of credit availability, balancing interest of all stakeholders, and establishing the IBC code. So this is the preamble of the IBC code. So that is the background also. The insolvency bankruptcy was enacted to consolidate and amend laws relating to insolvency bankruptcy code, ensuring a time-bound resolution process for stressed companies. However, MSMEs, due to their scale, MSMEs, due to their scale and resources constraints, face unique challenges in navigating the standard insolvency processes designated primarily for larger corporate entities. Recognize these challenges, the legislature introduced special provisions to facilitate more accessible, efficient, and less cumbersome insolvency resolution framework for MSMEs. Okay. Now, Section 240A introduced. Okay, application of the code to micro, small, and medium enterprises. As per Section 240 introduced, what are the objectives? Section 240A of the IBC was introduced to facilitate resolution and revival of MSMEs, allowing promoters, even those with NPAs or invoked guarantees, to submit resolution plans for their companies. These recognize the importance of MSMEs in the economy and their promoter-driven nature. So this section is very important from the point of view MSMEs. The treatment of MSMEs is done under this section 240. Okay, section 240A provide the benefit to the MSMEs companies, even if these MSMEs were in NPA or invoked any guarantee, still they can submit the resolution plan for their companies. So this is the benefit or additional advantage given to the MSMEs. Okay, so objective was that the MSMEs can submit their resolution even if they are in default. Default means related to NPAs, or if they have already invoked any guarantees, still they can submit the resolution plan for their company. Okay, now text of section 240A1, notwithstanding anything to the contrary contained in clause C and H of section 298, the said clauses shall not apply to the resolution applicant in respect of corporate insolvency resolution process of micro, small, or medium enterprises. Okay, means section 240A introduced for MSMEs. So there are certain advantages and benefit given in section 298. Okay, see here. We will discuss all the sections which are covered under 240A and under 290. See here, detailed clause-wise analysis of section 298 with MSMEs applicability under section 240A. Okay, there are sections 298 to H. Different sections are here. 298K. See here, we will discuss each section. See, there is a 290A section under discharge insolvent. Okay. A person who is an undischarged insolvent is disqualified. This section is also applicable on MSME. Okay, if MSME is going to submit the resolution plan, if any person is undischarged insolvent, is also disqualified. This section is also applicable on MSMEs. Okay, there are certain advantages given. See here, if you see 290 AC, that section is not applicable to MSMEs. Okay, so in this section is not applicable to the MSMEs. Okay, so we will discuss one by one. In case 290A undischarged insolvent, any person who is an undischarged insolvent is disqualified. This section is also applicable on MSMEs. Explanation: even in case of MSMEs, if a person is an undischarged insolvent, has not yet been legally discharged of debts, they are not eligible to be a resolution applicant. Okay, so means this is a standard section applicable to MSME. So in this section, no benefit will be given to MSMEs if they are undischarged or solvent. That section also will be applicable to MSMEs. Okay, now coming to another section. Is this section give benefit to MSMEs or not? 290AB, willful defaulter. Okay, a willful defaulter as per RBI guidelines under Banking Regulation Act or SEBI. Applicability to MSMEs. This section is also applicable. Okay, so means in this section also no benefit will be given to MSMEs if they are willful defaulter. Okay, MSMEs promoters who are declared willful defaulters by RBI cannot submit resolution plans. The rationale is to maintain ethical standards are discouraging fraudulent behavior. Okay, means if there is a person or a company or any resolution applicant who are undischarged, insolvent or willful defaulter, they will not be able to submit their resolution. Okay, so this section is also applicable to MSMEs. Okay, now see here in this section another 290AC is for NPA, non-performing assets. A person who has an account or is in control or management of a corporate debtor that has an account classification as NPA for 1 year before insolvency commencement and who has not paid the overdue amount before submission of the resolution plan. Okay, applicability to MSMEs not applicable. Lags under section 248. MSME promoters are allowed to submit resolution plans even if their companies or related companies account is NPA. This recognizes the financial vulnerability of MSMEs and seeks to encourage revival by experienced promoters. Okay, so this is a very important section from the point of view of MSME. So in this section means benefit is given to the MSME sectors. They can submit their resolution plan even if their company is in NPA. Okay, now another section is 29AD, convicted for offense. Okay, so this section is also applicable to MSMEs. Okay, a person convicted of any offense punishable with imprisonment of more than 2 years under laws specified in the 12th Schedule SEBI Act, Companies Act, FEMA, Prevention of Money Laundering, or more than 7 years under any law. Okay, means if any person convicted of any offense punishable with imprisonment of more than 2 years under this Act, SEBI, Company, FEMA, or more than 7 years in any other law, so that person is not allowed to submit their resolution plan. So that section is also applicable to MSMEs. If an MSME promoter has been convicted as described above, they are disqualified to ensure credibility and legal compliance. Okay, so means that promoter will be disqualified to ensure, because there is no capability of that promoter, and due to legal compliance as per as mentioned under section 290 AD, so that promoter will not be able to submit resolution plan. Okay, so this is also applicable to MSMEs. Okay. Now coming to the 290 AE, disqualified director. Okay, a person disqualified to act as a director under the Companies Act, section 164. Okay, if a promoter is barred from being a director, they cannot submit a resolution plan. This ensures that only compliant individuals take over test business. Okay, so this section is also applicable to MSMEs. So there is no exemption to MSMEs. If any director is disqualified under section 290 AE, so then that promoter or that director cannot submit the resolution plan. So this section is also applicable to MSMEs. Okay. Now there is another section 290 AF, prohibited by SEBI. A person prohibited by this SEBI from trading in securities or accessing capital markets. Okay. A person prohibited by SEBI from trading in securities or assessing capital markets, such persons are disqualified to protect investors' interest and market integrity. There is no assumptions for MSMEs. Means if any person is prohibited by SEBI, so then that person or that company cannot submit the resolution plan. This section is also applicable to MSMEs. So there is no benefit if in case of their default in SEBI and they have already prohibited that person or that director, so they will not be able to submit the resolution plan. Okay, see here. See, if you see now, there are two cases under section 290 where only exemption is given in 290 AC and 290 AH. Okay, there are only two sections where exemption is given to MSMEs. But we are discussing all the 29 so that we can understand what are the other sections which are not applicable or to MSMEs. Now coming to 290 AG, connected with another disqualified person. If a person is a promoter in a management control of a corporate debtor and that corporate debtor is disqualified under any of clause A to F, then that person is also disqualified. This section is also applicable to MSMEs. Explanation: if you are linked to any entity that is otherwise disqualified under A to F, you too are disqualified. This applies to MSMEs to avoid indirect circumvention of the law. So this section is also applicable to MSMEs. Okay, now there is another section 290 AH, personal guarantee involved but not paid. Okay, that person, in case MSME's personal guarantee involved but no payment not done, so that means they have done the default, but as per under IBC, so they have given the benefit. They can still submit the resolution plan. A person who has
Sir, excuse me, sir, one clarification. A company which is MSME under insolvency, the directors on behalf of the company, they are coming forward saying that they are MSME and eligible to give the resolution plan. But they are not providing the records of the company. So in such a
No.
situation, we cannot allow them to submit resolution plan, no?
Nee, for example, if they have given the personal guarantee, okay, and they have not means executed, they have not done the payment, still they will be able to submit the resolution plan. As per section 290AH, if that MSME can submit the resolution plan in two cases. They have given the benefit in under section 290AC or 290AH. 290 AAC for in case if that MSME is NPA, okay,
Mm,
till they can
mm.
submit the resolution plan, and if they have personal guarantee given, okay, and didn't do the payment, still they can submit the resolution plan.
Okay, I mean, their individual capacity you are telling, correct, no?
Yes, yes.
Yeah, on behalf of the company, the directors will submit now that they cannot do because they are not submitting the records. In that situation, they cannot submit resolution plan, correct?
That,
Two things are there, no, sir. On behalf of the company, directors only will submit the resolution plan. If unless they cooperate, they cannot submit the resolution plan.
that's what I'm
So
telling
we
you.
cannot allow them. But as a personal guarantor, also they can submit the resolution plan. No?
Hmm. You're right. That's what I'm telling you. Further, now there are case studies we will discuss now. So then we will be able to understand very easily. There are so many case studies which we are going to discuss.
Okay.
In the case of MSMEs, these clause doesn't apply. The promoter is still allowed to submit a resolution plan if their personal guarantee has been invoked and unpaid. Okay. This reflects a more lenient approach due to the importance of promoters' involvement in MSMEs. Okay, so this is also saying regarding personal guarantee. Personal guarantee means given by the promoter. A person who has executed a guarantee in favor of a corporate debtor and the guarantee has been invoked but remains unpaid. So that section is also not applicable to MSMEs, relaxed under section 248. In the case of MSMEs, this clause doesn't apply. The promoter is still allowed to submit a resolution plan even if their personal guarantee has been invoked and unpaid. Okay. This reflects that is the default at the end of the.
देखो ये चाबी देगा ना गाड़ी की
Hello. Couldn't hear you.
Yes, sir, we can hear you, sir.
Okay. I'm saying 290AH is not applicable to MSMEs. A person who has executed a guarantee in favor of corporate debtor and the guarantee has been invoked but remains unpaid. So that section is relaxed under section 240A. In that situation, also that MSC can submit the resolution plan only under section 240A. There are only two sections which give benefits to MSC. 290AC or 290AH. Other.
Sir, my question is, suppose the corporate debtor is a MSME and the debtors are eligible to submit the resolution plan. But suppose the debtor is also a debtor in any other company, which is not an MSME.
Just a 1 minute. Please speak loudly.
Am I audible? Sir, my question is, suppose the corporate debtor is an MSME unit, but the holding company of the corporate debtor is not an MSME unit. So still can the debtor submit the resolution plan?
Just give me 1
कैंटीन में तो
minute.
जात
There's
करना
very much noise.
हाफ पैंट पहन के कैंटीन में तो खाना जात करना हाफ पैंट हाँ
Just a 1 minute.
Someone is disturbing. Please mute yourself.
Bluetooth mode here.
Someone.
Yes, now you can tell me what was the question?
Sir, suppose the corporate debtor is an MSME unit,
Okay.
or the holding company of the corporate debtor is not an MSME unit. Still can the debtor submit the resolution plan?
See, if that MSE company means who is giving the personal guarantee? Personal guarantee is given by the promoter or company.
There is no personal guarantee. Suppose there is no personal guarantee. For example, there is no personal guarantee. Still, can the promoter submit the resolution plan?
The promoter can submit the resolution plan in case means only, for example, if there is any default at the end of the MSMEs, they cannot means in other company cannot submit their resolution plan. There are only benefit given to MSMEs if they are in a situation of NPA or if given personal guarantee. And the personal guarantee involved, that means they are in default. MSME has given the benefit. They can submit the resolution plan.
Sir, MSME should be corporate debtor. MSME is the promoter can may or may not be MSME. Okay. MSME should be corporate debtor. My
Yes.
point is corporate debtor is MSME, but the holding company of the corporate debtor is not an MSME. Okay,
So
sir.
then they can submit the resolution plan.
Okay, they can. Okay.
Okay, now there is another also sections under section 290A. There is another section 290AI, disqualified under foreign law. A person subject to any disability under foreign law, which is similar to clause A to H, applicability to MSMEs. This section is also applicable to MSMEs. This qualification based on foreign jurisdiction also apply to MSME applicants. No exemption provided under this section also. Another section is 290AJ, disqualified connected persons. A person who is a connected person, promoter, manager, or related party to a person disqualified under clause A to I. So this section is also applicable to disqualified connected person. This section is also applicable to MSMEs. There is no exemption to MSMEs under this section. Explanation: if any connected person is disqualified, the resolution applicant even for an MSME is also ineligible. This ensures the integrity of the resolution process. Now coming to the last one, there is another is 290AK, prior plan defaulter. A person who has failed to implement or pay as required under a previously approached resolution plan under the code. This section is also applicable to MSMEs. No exemption will be given to MSMEs in case of they have done any prior plan defaulter under section 290A. Okay. If they have done any default, prior plan default they have already done, so the exemption will not be given to MSMEs. Okay. So explanation: if an MSME promoter has earlier defaulted in implementing resolution plan, they are disqualified from submitting new plans, no reaction provided. So what we have understood ki in these sections, there are only two sections in which exemption is available to MSMEs: 290AC, where NPA default. Another is 290AH, where personal guarantee involved. See here, this is a table. With the help of table, we can understand very quickly. Section 290A, A clause A, B, C, D, E, F, G, H, I, J, K. What was the topic? We have discussed undercharged, insolvent, MSME status applicable, no relaxation. Willful defaulter, MSMEs applicable, no relaxation. Account for as the NPA, exemption given to MSMEs, relaxation under 240A. Convicted of offense, MSMEs, this section is applicable to MSMEs, no relaxation. Disqualified director, applicable to MSMEs and no relaxation is given. Prohibited by SEBI, this section is also applicable to MSMEs, no relaxation. Linked to disqualified entities, applicable, no relaxation. Guarantee involved and unpaid, that section is not applicable to MSMEs. Relaxation under given 240A. Disabled under foreign law, applicable, no relaxation. Connected person is disqualified, applicable, no relaxation. Defaulted on prior resolution plan, applicable, no relaxation. So for quick reference, we can understand with the help of this table. So these are the sections under section 290A and section 240A applicable to MSMEs. Okay. So with the help of section 240A and section 290A, we treat the MSMEs under IBC code. So now further we will also discuss the judgments given by honorable courts, NCLT and LCLT. So that will be really helpful for us to understand how we can manage and treat in case of any different situation comes, then how can we resolve this and take proper step to overcome that problem.
Sir, 299A-H, guarantee invoked but not paid. So the personal guarantor can give the resolution plan, correct?
Yes.
Okay.
I'm telling you that in only two sections, only exemption given to MSME promoters or directors. In, for example, in normal company, if when any normal person or normal company, in case of, for example, if there is a normal company, okay, and there is an NPA default, that company will not be able to submit their resolution plan. And if there is a person guarantor who actually person guarantor given but not done the payment, so that is the default at the end of the that company or promoter by a director. So they will not be able to submit the resolution plan. But here only these exemptions given to MSMEs, because as per law or as per these concepts, MSMEs are small companies. They face challenges, different challenges as compared to the normal companies. So that's why these exemptions are given to MSMEs companies, so that they can submit their resolution plan for their company also, so that they can survive and company can revive. So that is the logic and objective behind this assumptions. And for this purpose, for MSMEs, see, we also go through the pre-package insolvency resolution process. Okay, this is also very important from the point of view, MSME point of view. The pre-package insolvency process is an innovative insolvency mechanism introduced in India, especially to address the unique challenges faced by MSMEs and small companies under distress. For example, in case of normal company can bear the high cost, but MSE companies already facing challenges, finance challenges, because their level of activity, level of business is either small, medium. So, so miss that's why the relaxation given to MSME companies. It was the first introduced through an audience in April 2021 and later incorporated into the IBC to provide a quicker, cost-effective and less restrictive alternative to the traditional insolvency process. Okay, what was the key features? Hybrid of informal workout with and statutory process. PRP combined the advantages of informal resolution mechanism with the binding legal framework of the IBC. Okay, this creates a streamlined and effective process that leverages stakeholders' consensus while maintaining statutory safeguards. Okay, hybrid of informal workout and statutory process under the PRP. Introduced for the challenging faced by the MSME small companies. So that's why that pre-packaged insolvency process introduced. Now another was debtor in position model. Unlike the traditional CRP, where control shifts are resolution professional, under PRP the debtor remains in position and control of the enterprises. Okay. This helps maintain business continuity, preserve key operational relationships, and avoid disruption in day-to-day management. Okay, so that is the difference between normal CRP and PIRP. In traditional CRP process, what happens? Control shift to resolution professional. Under PIRP, the debtor remains in the position and control of the enterprise. This helps maintain business continuity, preserve key operational relationships, and avoid disruption in day-to-day management. So that is the difference between the traditional CRP and pre-packaged insolvency professional. Okay, now this is it. Normal CRP process is need to we have to complete it means that PRP need to complete in only 120 days. The PRP mandates complete of the entire resolution process within 120 days from the date of commencement. This is significantly shorter than the 330 days allowed under the traditional CRP. Okay. The shorter time frame reduce legal and administrative costs and minimize operational disruption. Okay. For example, if this matter will be resolved in 120 days, so then the means cost of legal cost and another cost will be at lower side as compared to the traditional CRP. The purpose is this key for MSME companies reduce legal and administrative cost and minimize operational disruption. So that was the logic behind for introducing the pre-packaged resolution process for MSMEs. Okay. Now, stakeholder engagement and consensus. PIRP places a strong emphasis on early and active involvement of stakeholders, especially creditors and the corporate debtor. The resolution plan is designated through consensus building between the debtor and creditor, ensuring greater cooperation. Okay, now stakeholder engagement and consensus is the important role in the package insolvency resolution process. Okay, now coming to the approval by financial creditor. For the PIRP, resolution plan is to be accepted. It must receive approval from the unrelated financial creditor holding at least 66% of the voting share. This threshold ensures that the plan is acceptable to a significant majority of the creditors, maintaining fairness and transparency. Okay, so in traditional CRP also we take approval from means creditors from COC, and here in PIRP we take approval from financial creditors, unrelated financial creditors holding at least 66% of the voting share. Now, mandatory disclosure and transparency. The corporate data is required to disclose all assets and liabilities upfront. This ensures transparency and allows creditors to make informed decisions about the resolution plan. Okay, now what are the benefits for the pre-packaged insolvency resolution process? Benefits for MSMEs, speed and cost effectiveness, faster resolution, because the time period is 120 days against 130 days. If there is a faster resolution, so that helps to reduce the financial and operational burden on MSMEs. Okay. Business continuity, debtors maintain control, helping sustain operations and safeguard relationship with customer, supplier, and employee. Okay. Here, debtor control. In traditional CRP, debtor control is under the insolvency professional. In PIRP, debtor control will not be under the resolution professional. So this thing really helps to run business smooth. So this really helpful for business continuity, because management or other person also have their direct relationship with the debtors and suppliers and employees. So they don't face any means operational issues. So business can means be done smoothly in this situation as compared to the traditional, because when insolvency professional will take over and manage with the suppliers and customers, they will have to means again start maintain the relationship, which is not possible in such a short period. So reduce litigation. Consensus driven approach lowers adversarial disputes and potential litigation. Okay, so this will also help to reduce the litigation, because this the time frame is only 120 days. If time is 120 days, so then that your problem will be solved. So it also helps to reduce the litigation. And this is also a very simplified process. Tailored procedural requirements make it more accessible for smaller enterprises. Okay, so that was the objective and benefits for MSMEs. Okay, see, This is really very helpful and important from the point of view MSMEs. Why? Because this is a time bound within 120 days as compared to 330 days. Okay, that is one aspect, and another aspect is debtor control. Okay. Now, see, we can understand with this table. Pre-packaged insolvency resolution process, comparison PRP versus traditional PRP. Control. In PRP, debtors in position, okay, will not be in the hand of the resolution professional. That will be in the hand of the management. In traditional CRP, control transfer to resolution professional. There is a time limit. In PIRP, time limit is 120 days. In traditional CRP, 330 days. Process या nature. Pre-negotiated. Okay, pre-negotiated and consensus driven. Here, formal code driven. Adversarial. Okay, the cost. Lower cost due to short time period. Okay, and fewer legal hurdles. In this case, higher due to longer duration and complexity. Okay. Stakeholder approval. In both the cases, we need at least 66% of voting share of financial capital. Okay. Transparency, mandatory full disclosure of assets and liabilities. Okay. Here, disclosure as per CIP requirements. So this is the comparison between traditional CRP and PRP. PRP is for MSMEs. Okay. Now, conclusion, the pre-packaged insolvency resolution process offer MSMEs a more practical, efficient, and less disruptive mechanism for insolvency resolution, addressing the limitations of the traditional CRP framework and promoting quicker recovery or restructuring. Okay. Summary, the pre-packaged insolvency resolution process offers MSME as more practical, efficient, and less restrictive mechanism for insolvency professionals, addressing the limitations of the traditional CRP framework and promoting quicker recovery or restructuring. Okay. Now, with the help of the judgments, okay, we will understand how to treat MSMEs under IBC. And we will also, after these topics, we will also discuss how to manage hostile takeover. Now, coming to this Supreme, there is a very famous judgment, Supreme Court judgment, Swiss Ribbons Private Limited versus Union of India. Okay, see here, there is section 298. Okay, disqualification of relation professional is given. Okay, so we will discuss this case. See how MSMEs are exempted. Okay, see here, the Supreme Court landmark judgment in Swiss Ribbons Private Limited versus Union of India, reported 2019, is a foundational decision upholding the constitutional validity of the IBC Code 2016. It laid down an important principle that not only fitted the IBC framework, but also had far-reaching implications for all stakeholders, including micro, small, and medium enterprises. Background. This was the background. Challenges. The petition challenges various provisions of the IBC. Section 7, initiation of CRP by financial creditor. Section 12, withdrawal of insolvency professional. Section 290A, disqualification of resolution applicants, role of resolution professionals, unequal treatment of operational creditors versus financial creditors, overall classification of creditors. So these were the challenges. Means from the petitioner. Now, what was the key issue in this? Key issue and Supreme Court's ruling, constitutional validity of IBC. Okay, now we will go through one by one. The court upheld the constitutional validity of the IBC in its entirely recognized IBC and is as an economic legislation designated to revive corporate debtors in a time-bound manner and to protect the interests of the shareholder. Okay. So these were the key issues means discussed under the Supreme Court rulings. Okay, now another one was classification between financial and operational guider. Issue. Petitioners argued that giving preference to financial guiders under the Committee of Guiders violated Article 40 equally. The ruling, the court held the classification is reasonable because financial guider assess the viability of the resolution plan. Operational guider don't have the same capability. Okay. Different roles in credit exposure and risk assessment justify different treatment. So that ruling was given by the Supreme Court because issue was that ki financial guider is treated or given preference as compared to the operational guider. So court says ki financial guiders preference should be given to the financial guider as per under this act because financial guider assess the viability of the resolution plan. Operational guider don't have that much capability. So that's why priority need to be given to the financial guider. There are different roles for financial guider and operational guider. Okay, what is the different role? Credit exposure and risk assessment. Is it different? Means there is a credit exposure related to financial guider. Okay, and there is a risk assessment. So on that basis, means there should be a classification, and that classification is a reasonable. Another third one was Section 290A, ineligibility of certain provision persons to submit resolution plans. Court upheld the bar on promoters who contributed to a debtor's default from bidding under the IBC, stating that allowing them to regain control defeats the objective of resolution. Okay. However, acknowledged need for relaxation for MSME, especially under the Section 248, which empowers the government to exempt MSMEs for some sections to 29A sections. Okay, so that was the objection is submitted by the petitioner. There is the ineligibility means under Section 290A, there is the ineligibility means everyone cannot submit the resolution plan. So there is the means ineligibility defined under the Section 290A, which we have already discussed, 29 to 29K. But in some of the exemptions in given to MSMEs, so that was the objection submitted by the petitioner in this case. Now, fourth, role of resolution professional rejected the argument that RP act as a quasi judicial authority, clarified that the RP doesn't educate but only manage the process and submit finding to the COC. Okay, so the question was also raised for the role of resolution professional. Okay, now another objection was Section 12A, withdrawal or application. Upheld the validity of Section 12A, which allows withdrawal of CRP only the approval of 90% of COC. The court found that provision promotes speedy resolution and avoids misuse of the insolvency process. For example, in case if any CRP application is submitted, okay, if option is given under Section 12A, if CO in case of 90% of voting right approved under the COC, okay, so then under the Section 12A means that petition can withdraw. Okay, so that is given in this situation. What happens? So they will manage the business at their end, and it's also a very speedy resolution and avoid misuse of the insolvency process. Okay. Now, another was validation of Section 240A. The court recognized the hardship faced by the MSMEs under IBC. It emphasizes that Section 240A was inserted to relax the strict disqualification norms for MSMEs under Section 29A. The facilitators, promoters of MSMEs to submit resolution plans, even if they are classified as an NPA, allowing business continuity. Okay, so This is also purely pertaining to the MSMEs. Means here section 240A introduced only for the MSMEs. Under this section, there are exemptions given to the MSMEs. Okay, so the objection was raised by the petitioner also against this section for this part also. Encouragement of resolution over liquidation. The judgment emphasizes resolution as the primary objective, which is, see here, now we are discussing impact on MSCs. Okay, now encouragement for resolution over liquidation. The judgment emphasizes resolution as the primary objective, which is a particularly critical for MSMEs whose business viability can often be revived with proper restructuring. Helped shape the later introduction pre-packaged insolvency resolution process for MSMEs. Okay, so see what is the impact on the MSMEs. First was validity of section 248. Second was encouragement for resolution over liquidation. Okay. For example, if there is a MSME company, for MSME companies, pre-packaged insolvency resolution process introduced, which helps MSMEs to resolve and come out of this problem. Okay. Another was protection for operational guidelines, which includes many MSMEs. Although the court upheld the unequal treatment, it mandated that the operational guideline must receive at least the liquidation value and their interest should not be disregarded. So the third impact is protection for operational guidance, which includes many MSMEs. Okay. Now, what was the conclusion? Swiss Ribbon versus Union India is a milestone in the evolution of the Indian insolvency law for MSMEs. The judgment protected their ability to revive businesses through relaxed norms, ensure fair treatment in the resolution process, promoted the introduction of MSMEs specific mechanism like PRP, upheld the IBC's constitutional foundation, ensuring long-term stability of the insolvency regime. That was the conclusion. Okay. Means, if I say in this, all these petition filed the objection for these sections under the IBC. The petitioner challenged various provisions of the IBC. Okay, in these provisions, sections are mandatory under the IBC code. So we have already discussed all these sections. So these are the part and parcel of the IBC code. So they said and approved the validity of these sections and also means confirmed the objective and the logic for these sections. Okay. Now there is another judgment. Hari Babu Kota versus Committee of Creditors. Okay. In this MSME means in this situation, what happened? For example, if there is a MSC company, they can take the benefit of or take the exemption benefit. Okay, if for and in case that company is in CRP and during the CRP, if that company take the MSME registration, okay, so in this situation, what will happen? That company will be able to take the benefit of MSME or not. Okay, so this thing we will discuss under this judgment. The Supreme Court decision in Hari Babu Kota versus Committee of Creditors delivered on November 23 is a landmark ruling that clarifies that eligibility of promoters of MSMEs to submit resolution plans under the IBC, even if MSME registration is obtained after the initiation of the CRP. Okay, Now, that was the background. Corporate debtor was Shiri, Asharya, Infra Fund Limited, CRP, started in April 6, 2021. MSME registration obtained during CRP prior to submission of the resolution plan. Now, question comes here. CRP started. Okay. Company was not having the MSME registration. If company is having the MSME registration, they can take the benefit or the exemption given under section 29C or 29H under section 240. Okay. Now, CRP already started. But resolution plan is to be submitted. Okay. There is a time gap. In this time gap, if any company registered under MSME, is this thing exemption will be available to that company or not? See here, the resolution submitted by the promoters post MSME registration. The resolution professional Harry Babu facilitated the MSME registration during the CRP to keep the corporate debtor as a going concern. Subsequently, the promoter submitted a resolution plan which was approved by the COC. Okay. Now, eligibility. Under section 29A, whether promoter disqualified for submitting a resolution plan under section 29A of the IBC if MSME registration is obtained after CIRP initiation. Okay. Yes.
But I think there is a circular has also come from the IBBI that even if the company was not get the certificate prior to the IBC, prior to the CRP, it is a duty of the RP to get the post CRP certificate of MSME. Am I right?
Yes, yes, that's what I'm telling you. Na, when we will discuss this judgment, it will clear to you. For example, if CRP started, okay, resolution plan not submitted in this period, okay, if MSME certificate is taken, so then exemption will be given to that company. See here, eligibility under section 29A, promoter are disqualified. Okay, MSME registration is obtained after CRP initiation. Whether the exemption provided under section 248 apply when MSME registration is required for CRP initiation. See here. The Supreme Court overturned the decision of the NCLT and NCLAT, which had held the promoter ineligible. The court held eligibility at a plan submission. The relevant date for determining eligibility under section 29 is the date of submission of the resolution plan, not the date of CRP initiation. Section 248 exemption, promoter of MSMEs are exempt for certain disqualification under 29A, specifically clause C and H, allowing them to submit a resolution plan even if the administration is obtained during CRP. Okay. Policy consideration, the court emphasizes the importance of MSMEs in the economy and the need to facilitate their revival rather than pushing them into liquidation. Okay. See here, before resolution plan, so they can take the benefit. Okay, that means here, see here, legal issue was that eligibility under section 29A, whether promoters are disqualified from submitting a resolution plan under section 29A of the IBC if MSME registration is obtained after CRP initiation. Okay, applicability of section 240, whether the exemption provided under section 248 apply when MSME registration is required post CRP. So that was a legal issue. So what was the ruling said? The Supreme Court overturned the decision of the NCLT and NCLAT, which held the promoter ineligible. The court held eligibility at plan submission. The relevant date for determining eligibility under section 29 is the date of submission of the resolution plan, not the date of CRP initiation. Okay, means if MSME company take MSME decision post CRP, so they are eligible to take exemption. Because for this thing, because they are to submit the resolution plan. Okay. So if they can submit the resolution as in CRP phase, if they take the decision under MSMEs, so they can do submit the resolution plan. Okay, so court clearly mentioned the criteria will not be CRP initiation. The criteria will be the date of submission of resolution plan. Clear? See section 248 exemption. Promoters of MSC are exempt from certain disqualifications under section 29, especially clauses C and H are allowing them to submit resolution plans even if MSME registration is obtaining during CRP. Okay, so they can take the exemption benefit under section 290 ACH under section 240A. So they can take the benefit of exemption under this section. The purpose is that the purpose and logic behind is this: the court emphasizes the importance of MSMEs in the economy and the need to facilitate their revival rather than pushing them into liquidation. Okay. With the help of this judgment, we can understand if there is a MSME company already registered under MSME, so they can get the benefit of section 299A C or H under section 248. But if during the CRP that company take registration, MSME registration, okay, so they can also allow to submit the resolution plan. Basically, the criteria is for exemption is not the initiation of CRP date. The criteria will be date of resolution plan. So with the help of this judgment, we can understand and we can manage and tackle this situation. If any company means for you are means taking care any company as a means so then you can suggest if as a IRP or means any person can take the means take a registration under MSMEs for the purpose of getting benefit of exemptions under these sections. This is very important case. See, Swiss ribbon case is very important because so many sections challenged by the petitioner and judgment given to clarify all those sections very clearly. So this is very helpful for another cases. This is the landmark judgment. And if we discuss this Hari Babu Kotak versus Committee of Creditors, this is also very helpful to understand whether MSME will be able to get the benefit in case if they take a decision under the CRP. But before the submit of a resolution plan, okay, they will be eligible to submit the resolution plan or not. So with this judgment we can understand easily. Okay. Okay, we can take 5 minutes rest. Okay. If you take 5 minute rest. Okay. मुस्कान पानी दे देगी जरा, मेरा पानी की बोतल मंगाओ, जल्दी दे पानी। Okay, let's start. Okay, there is another case. Pro NITS versus the board of directors. Okay. The Supreme Court decision on Pro NITS, the board of directors of Canara Bank and others, delivered on August 2024, stands as a pivotal judgment concerning the treatment of micro MSMEs under financial distress. The court emphasized that mandatory nature of the framework for revival and rehabilitation of MSMEs issued by the MSMEs in 2015, ascertaining its binding effect on all scheduled commercial banks. What was the issue? The petitioner was Pro NITS and that was an MSME engaged in textile manufacturing. Respondent was Canara Bank as scheduled commercial bank. What was the issue? Issue was Pro NITS challenged the classification of its loan account as a NPA and subsequent recovery actions under the Surface Act 2002, alleging non-compliance with the mandatory restructuring process outlined in the framework. High Court proceeding, the Bombay High Court dismissed Pro NITS writ petition holding that the frameworks were merely directory and not mandatory. Supreme Court appeal, Pro NITS appeal to the Supreme Court contesting the High Court's interpretation and the bank's action. So then statutory forces of the framework, the court held that the framework issued under Section 9 MSMAD possesses statutory force and is binding on all scheduled commercial banks. Mandatory compliance before NPA classification. Banks are obligated to follow the procedure outlined in the framework before classifying an MSME account as an NPA. This includes identifying early signs of the financial stress and exploring restructuring options. Non-compliance, invalidation, subsequent actions, failure to adhere the framework renders subsequent actions such as the NP classification, enforcement of Surface Act. Okay, obligation of MSMEs, where banks have a duty to follow the framework. MSMEs must also be proactive in providing necessary documentations to avail themselves of the restructuring benefits. Okay, now what was the implication of the judgment? Hence, protection for MSMEs. The judgment reinforced the protective measures available to MSMEs, ensuring that bank cannot bypass the restructuring process before initiating recovery action. Okay, Clarification on legal hierarchy. The decision clarifies that provision of MSME Act and the framework take precedence over the Surface Act in matters concerning MSME loan restructuring. Okay. Banking practices. Bank must follow the framework procedure promoting a more structured and fair approach to handling MSME financial distress. In critical analysis, the landmark ruling underscores the judiciary recognition of the unique challenges faced by MSMEs and the necessity of supportive legal framework to address financial distress. By mandating strict adherence to the restructuring process, the court aims to prevent premature and potentially detrimental recovery actions, fostering a more resilient MSME. This MSME sector, MSME Act, given the benefit and advantage, there certain procedures should be adopted by a bank before taking any action, and if any asset is going in NPA, so they can also take the appropriate action and can take means and discuss with the MSME companies. Okay, but all of a sudden they cannot take action, surface action. Okay, the objective is this: the MSME is also facing challenges and in financial distress. So there must be a proper procedure should be followed for MSME sector as per the MSME Act. And there is another judgment on High Court, also on NPA. The Karnataka High Court ruling in Metro Steel sections. That case was Metro Steel section versus State Bank of India. What was the background? Petitioner was Metro Steel section. Respondent was SBI. Loan details: Metro Steel section secured 15.5 crore fund base CC limit under the MSME agreement. Okay, so that MSME company taken the CC limit under the MSME agreement. Operation declined. The company's operations began in August 2023, leading to the payment and fee classification done in 2023 and transferred to SBI Stress Assets Management branch. The legal action taken: Metro Steel section contested SBI's recovery proceeding, arguing that the bank failed to adhere to MSME revival and rehabilitation guidelines. Court finding ineligibility for MSME's benefits held that companies which have ceased operations for 2 years are not entitled to benefit under the MSMEs. Okay. MSME companies will take assumption and take benefits, but if company is not in doing operations for since last year, so then that company will not covered under MSME benefits. Just open. Admission of closure. The court noted that the Metro Steel section had admitted to ceasing operations 2 years prior, hereby disqualifying itself for MSME relief measures. Futility of revival efforts. The judge emphasizes that attempting to revive or restructure a defunct business would be futile, likening it to flogging a dead horse. Validation of SBI's action. The court found no fault with SBI's recovery efforts, stating that recovery remains the sole option when rectification and restructuring are unfeasible. Operational status is crucial. MSME benefits under the IBC are contingent upon the enterprises being operational. Non-operational entities are ineligible for such relief. Okay, so that is very important from the MSME point of view. If any company want to take exemption or benefit, so that company must be company must be operational and not be non-operational. Okay. If any company is not in doing operation since 2 years, so that company will not be able to take the benefit of exemptions. Banks' obligation. Financial institutions are not mandated to pursue revival or restructuring plans for companies that have ceased operations, even if they fall under the MSME categories. Precedent for future cases. The ruling sets a precedent that could influence how courts interpret the applicability of MSME benefits for non-operational firms under the IBC. Okay, for this judgment, we can understand if there is a company having a registration under MSME, that it doesn't mean that they will get the exemption benefit. They can get the exemption benefit when they are operational. If that company is non-operational more than 2 years, so that company will not be considered an MSME and will not be able to get any exemption or any benefit under the MSME Act. So that judgment is also very important from the MSME point of view, whether operational or non-operational firm can get the benefit under the MSME Act or not. So that is very crucial judgment from that point of view. The judgment underscores the importance of maintaining operational status for MSME seeking relief under the IBC. It delineates the boundaries of the MSME framework, ensuring that benefits are extended to viable enterprises capable of revival. That decision also provides clearly to financial institutions regarding their obligations, emphasizing that recovery efforts are justified when revival is not a feasible option. Okay. When any bank is taking any appropriate action. Okay. And if company is non-operational, so then it will be good to take appropriate action because that company will not be able to survive when they are not operating more than 2 years. That means that is non-operational. So then in that case, no benefit should be given under MSME. So that was the critical analysis. Okay. Now there is another High Court judgment. Mahanagar Telephone Nigam Limited versus Delhi International Arbitration Center and others. Okay. Background: parties involved, Mahanagar Nigam Limited and another is service provider, Delhi International Arbitration Center. There was a contract detail. MTNL issued a letter of intent to the service provider for architectural consulting services with a fees of 2.97% of the project estimated. The dispute: service provider rendered services and submitted bills, but MTNL failed to make the payments. Okay. MSME registration: the service provider registered as an MSME in 2018. Okay. See here, contract was done in 2006, but MSME registration taken in 2018. Now, there was an arbitration initiation. Post registration, the service provider approached the MSME Facilitation Council to claim unpaid dues, leading to the referral of the dispute to the DIAC. MTNL's objection: MTNL challenged the arbitration referral, arguing that since the contract was executed before the service provider MSME registration, the MSME Act provision, including arbitration, were inapplicable. What was the court's finding? Prospective application of MSME Act, the court held that benefits under the MSME Act, including the right of arbitration under Section 17 and 18, apply prospectively from the date of MSME registration. Therefore, dispute arising from contracts executed before such registration are not eligible for arbitration under the Act. Justification of registration: the court notified that objections regarding the applicability of the MSME Act to pre-registration dispute should be raised before the arbitrator under the Arbitration Consultation Act. That was the court's finding. Reference to Supreme Court proceeding: the judgment cited. Okay, now we will see what was the implication of the judgment. Timely MSME registration: entities must ensure MSME registration before entering into contracts to avail the Act's benefit. Okay, see here, contract was done in 2006, MSME registration taken in 2018. So what was the judgment and given by the Supreme Courts? What was the implication on this judgment? There should be a timely MSME registration. It should not happen when everything is over and you are taking MSME registration and you are saying we are eligible for to take the benefit of MSME. So that is not possible. Timely MSME registration means entities must ensure MSME registration before entering into contracts to avail the Act's benefit, including arbitration mechanism. Limitation on MSME's council's jurisdiction. The MSME Facilitation Council cannot entertain disputes related to contracts executed prior to an entity's MSME registration. Alternative legal remedies. For dispute arising from pre-registration contracts, entities must seek remedies through conventional legal channels such as civil suit or arbitration under the Arbitration Act 1996 if an arbitration agreement exists. The critical analysis, the ruling underscores the importance of MSC registration timing in determining the applicability of MSMED's Act protective provisions if delineates the boundaries of the MSC Council jurisdiction, ensuring that only disputes arising post-registration are subject to its arbitration mechanism. Business should prioritize timely MSME registration to fully leverage the act of the benefits. For this judgment, we can understand if any entity want to get the benefit or exemption under the MSME Act, that entity will have to take prior registration under the MSME Act, number one. Number two, if there is any dispute, if there is any dispute, any claim before registration, so then facilitation center don't have jurisdiction to solve or to enter or to resolve this issue. Means there is a limitation on MSME councils. Okay, they cannot entertain the dispute which arise before the registration, MSME registrations. Okay, so with the help of this judgment, we can understand if entity want to get benefit, so we'll have to take prior registration. Okay. There is another landmark judgment given by the NCLT. Okay, see here. The National Company Law Tribunal, Kolkata branch, has rendered several significant decisions regarding the registration of micro, small during the CIRP. These rulings have clarified and the applicability of Section 240A, which provision certain relaxation for MSME. Okay. See here. Dharamveer Singh and Daulat Ram Jain. Background: the corporate debtor Hardlock Attachment Private Limited was undergone CRP. The suspended board sought MSME registration during the process. NCLT directive the tribunal directed the RP to register the corporate debtor as an MSME under the revised definition effective 2020. The NCLT observed that the corporate debtor was eligible for MSME registration and thus that such registration would enable it to avail various benefits under the MSME Act and other government schemes. Okay. See here, if any company is in CIRP, okay, if they will take the benefit of MSME, so during the CIRP, professional, if facing any challenges, and if they take the registration of MSME, so they can take the benefit and exemptions and also take the benefit of the government scheme. So then revival of that donation will be easy. So that's why in case during the CRP, if that company is eligible for MSME, so an IP should take get the registration of MSME. Okay, see here. Now, the NCLT observed that the corporate debtor was eligible for MSME registration and thus such registration would enable it to avail various benefits under the MSME Act and other government schemes. Okay, now coming to another to variate global case. Reference given. Background. A registered MSME was admitted into CRP. The suspended director sought relaxation for the net worth eligibility criteria for submitting a resolution plan. NCLT ruling, the tribunal held that MSME promoters could be relaxed from the net worth eligibility criteria submit the resolution plan, but are required to deposit the security deposit or NS money deposit. The NCLT emphasized that while Section 240A provides certain relaxation for MSCs. It doesn't exempt from them from all requirements. The deposit of security deposit and EMD ensures that seriousness and genuineness interest of the resolution applicant in reviving the business. MSC registration during CRP. The NCLT has affirmed that a corporate debtor can obtain MSC registration during CRP. Such registration enables the application of Section 240A, allowing promoters to submit a resolution plan, provided they are not willful defaulter or otherwise disqualified under Section 290A of the IBC. Okay, we have already discussed sections 290A to K. Okay. Relaxation of eligibility criteria. While MSME promoters may be exempted from certain criteria, eligibility criteria, such as net worth requirement, they are still obligated to fulfill other conditions like depositing security deposit. This balance ensures that the resolution process remains fair, that only serious applicants are satisfied. For example, if any resolution plan is submitted by any other promoter, any other director, any other company, so they are bound to deposit security deposit. Okay, but MSME under Section 248 and under Section 298 have exemptions for 290A-C, 290A-H. Okay, but there is no section available which is giving exemption to MSMEs for non-depositing security deposit or EMD. Okay, so if in case of MESME is entity is there, so this action means that entity will have to submit the security deposit like another company or another promoter or other resolution applicant. So there is no reaction available to MSME companies regarding regarding no depositing security deposit or EMD. Okay. So see here. Promoters of MSME undergoing CRP can leverage the provision of Section 248 and by obtaining MSME registration during the process, enabling them to submit a resolution plan and potentially regain control of their enterprises. Section 248 gives the benefit, exemption benefit. Okay, so that is the benefit for to MSMEs. Resolution professionals RP should facilitate the MSME registrations of eligible corporate debtors during CIRP to maximize the chance of successful resolution and to align with the objective of the IBC. Okay. Creditors and COC. The Committee of Creditors should consider the benefits of allowing MSMEs promoters to submit resolution plans, especially when such plans may offer better value realization compared to liquidation. Okay. Means in this judgment also clearly mentioned promoters can get the exemption benefit or benefit under Section 248 under 290A, but only those exemptions available which is provided under Section 290A. Other than these, another as a special means exemption, separate exemption is not given regarding not to submit the security deposit or EMD. Okay. Now there is another judgment. This is also very critical judgment for MSME point of view. There was a corporate debtor, Simplex Project Limited, operational creditor, Vedic Projects Private Limited. CRP initiated in 27th April 2022, initiated by the SEBI. Claim detail, Vedic Projects failed a claim totaling 23.42, comprising the principal amount and interest calculated under the MSMED Act. Okay. Now, interest claim rejection. The NCLT Kolkata bench held that interest claimed under MSMED Act does not automatically qualify as an operational debt under Section 521 of the IBC. Reasoning, the tribunal implies that unless the interest component is mutually agreed upon in the contract or expressly admitted by the corporate debtor, it cannot be treated as a part of the operational debt. Okay. Now NCLT affirmation. Appeal dismissed. Vedic project appealed NCLT's decision to the NCLAT, upheld NCLT's ruling, reinforcing the statutory interest under the MSME Act. In the absence of mutual agreement or admission, is not eligible during CRP. What were the legal implications? Operational debt definition. The case clarifies that for an interest component to be included in an operational debt under the IBC, there must be a contractual agreement. For explicit
एक आदमी के अर्बन ये जाने वाला
please mute someone is mute someone. Please mute someone is unmute. Okay. Okay, now operational debt definition. The case clarifies that an interest component to be included in operational debt under the IBC, there must be a contractual agreement and explicit acknowledgement by the debtor. MSME's consideration. While the MSME Act provides for interest on delayed payments to MSMEs, such statutory interest claims are not automatically enforceable in insolvency proceedings unless they meet the criteria set under the IBC. Here, what was the issue here? If there is any operational debt, okay. So if operational debt taken 1 crore rupees, if there is the interest part is also there. If there is a contract and debtor agree, if there is a contract, as per a contract, you can means claim under the IBC. If another part is this key, if debtor also acknowledge, then you can claim. But under IBC, there should be a contractual agreement for claiming the claim. Okay. Means under MSME, statutory interest claims are not automatically enforceable in insolvency proceeding. Okay, unless they are meeting the criteria under the IBC. Expert commentary means the decision in this case underscore the importance of clear contractual terms regarding interest on delayed payment. MSME should ensure that their contract explicitly states interest obligation to strengthen their claims in the insolvency scenario. Means if any person is submitting any claim, means operational character claim, they can also means claim for interest part, but as per the agreement, if there is agreement between two parties, if they will not make the payment on due or due time, so then there will be interest will be charged at this percentage or whatever they have mentioned in agreement as per the legal scenario. So that interest can be claimed under the IBC in case if there is an agreement, contractual agreement. There must be a contractual agreement. Another part is this: if, for example, if there is not agreement, and in normal business scenario we have discussed, and the same has been acknowledged by the debtor. If we have the evidence, then we can also claim, means interest part with the operational debtor. In this judgment, focused on the operational kite claim and with interest part on the operational debtor. Can we claim for interest or not? This thing is clarified in this judgment. So this judgment is also very important from the point of view, MSME point of view, because if when you are doing any CRP proceeding, if any claim comes, so then if there is a contractual agreement, so then you can means you can accept that interest part along with the operational credit. Okay, so In this way, you can means treat MSME, operational character and interest part under the IBC code. Okay. Now there is another NCLT judgment on this part also. The eligibility of promoters of a corporate debtor to submit a resolution plan under the IBC code, even when the CD obtains micro registration after the initiation of PIRP, has been subject of legal scrutiny. In this case, what was there is a background. In this case, Hari Babu Thota, Committee of Creditors, Shri Ashwarya, the CD was admitted in 6/2021. Subsequently, 15th July 2021, the CD obtained MSME registration. The promoter submitted a resolution plan, which was approved by the COC. Okay. CD admitted, CRP admitted on 6 April 21. MSME registration certificate taken on 15 July 2021. However, the National Company Law Tribunal rejected the plan on 15th July 2021. The plan was approved by the COC, but the same plan was rejected by the NCLT, stating that MSME certificate was obtained post CRP initiation, rendering the promoters ineligible under section 29 of the IBC. Okay, three things coming here. CRP initiated 6 April 21. MSME registration certificate taken 15 July 21. NCLT rejected that plan because MSME registration certificate taken after initiation of CRP. Okay, so as per NCLT, promoters are not eligible for submitting resolution plan under section 29A of the IBC. What is the Supreme Court ruling? The matter related to Supreme Court, which was overturned the decision of both the NCLT and NCLAT. The court held promoters eligibility. Promoters of a CD are not disqualified from submitting a resolution plan under section 29A. We have already discussed this thing. During CRP, MSME can take the registration. Okay. The CRP initiation date is not the criteria. Resolution plan, timing of resolution plan is the criteria for submit a resolution plan. Okay. The same thing is in this judgment. Promoters of a CD are not disqualified from submitting a resolution plan under section 29A of the IBC solely because the MSME registration was obtained after the initiation of CRP. Okay. Now, section 240A, exemption. Section 240A provides exemption to MSME. Certain provisions of section 29A. The Supreme Court says that these exemptions apply even if the MSME status is required post CRP initiation, provided the resolution plan is submitted after obtaining the MSME certificate. Okay. Again, I'm telling you, section 24A exemption. Section 24A provides exemption to MSMEs from the certain provisions of section 29A. The Supreme Court emphasized that these exemptions apply even if the MSME status is required post CRP initiation, provided the resolution plan is submitted after obtaining the MSME certificate. Objective of the IBC, the court underscored that the IBC aim to ensure the revival and continuation of the CD by protecting it from its own management and from a corporate debt by liquidation, allowing promoters of MSMEs to submit resolution plans aligns with this objective. See, again, you see here, what was the issue? CRP initiated 6 April 21. MSME registration certificate 15 July 21. NCLT and NCLT rejected this plan because as per NCLT and NCLT, promoters are not available because they have taken registration certificate after initiation of CIRP. Okay. But as per law, as per Supreme Court judgments, above we have already discussed above. In case post MSME decision is taken, okay, so then promoters are allowed to submit their resolution plan. It doesn't affect if they have taken MSME post registration, because the criteria is not a CRP initiation. The criteria is timeline of the resolution plan. So here also Supreme Court, as the Supreme Court's ruling, they are clearly mentioned or cleared. Promoters are eligible. They will not be disqualified for submit the resolution plan under section 240A or under and 290A. Okay, because there are certain assumptions given to MSMEs under section 240A and 290A, under 290AC and 290H. Okay, so these assumptions provides MSMEs some assumption and benefit. So these on that basis, MSMEs are after post CRP initiation, but provided the resolution plan is submitted after obtaining the MSME certificate, they are allowed. Okay, the objective we already discussed, because objective is this: keep as per MSMEs, the court underscored that the IBC aims to ensure the revival and condition of the CDs by protecting them it from its own management and from a corporate death by liquidation, allowing promoters of MSMEs to submit resolution plans aligns with the objective. Okay. Now, what are the implications for promoters? Promoters of MSMEs can submit resolution plan even if the MSME decision obtained after the initiation of CRP, provided the plan is submitted thereafter. Okay, so then there is no problem. For resolution professional and COC, they should consider resolution plan submitted by promoters of MSMEs irrespective of the time of MSME registration, as long as the plan is compliant with the provision of the IBC. If the plan is compliant with the provision of the IBC, so then there is no problem. If a registration done post CRP, means after initiating CRP, they are allowed to submit the resolution plan. For adjudicating authority, now we are discussing implications. Implications for promoters for RP and COC and for adjudicating authorities. So these, what are the implications we are discussing under this judgment? For adjudicating authorities, NCLT should not reject resolution plan solely on the ground that MSME registration was obtained post CRP initiation. Okay. So there were the three main implications highlighted under this judgment for promoters, for resolution professionals, for adjudicating authority. Now coming to the conclusion, the Supreme Court decisions clarifies that the timing of MSME registration, whether before or after the initiation of CRP, doesn't in itself disqualify promoters for submitting a resolution plan under the IBC. This interpretation supports the broader objective of the IBC to facilitate the revival of viable business and preserve employment. Okay. CLAT, dismissal of the insolvency plea against PepsiCo India, connects to MSME and their rights under the IBC, especially considering MSME protections, contest MSE and IBC. MSME often delayed payments and financial stress. IBC provide a formal resolution mechanism, CRP, for recovery of dues, including from larger entities. MSME have specific safeguards like Section 248, easing their insolvency resolution process. However, IBC is not meant to be a shortcut for debt recovery, but a genuine insolvency resolution framework. Okay. Now coming to key learning from PepsiCo case agreement to MSMEs. What was the key learning? Principal debt must be clear and undisputed. In the principal case, the principal amount was paid during litigation. Only the interest remained remained disputed. The enclave held that CRP cannot be initiated on disputed or only interest claims. For MSMEs, this reinforces the need to have undisputed principal dues before filing for the insolvency. If there is a genuine dispute, CRP may be rejected. Now, IBC cannot replace debt recovery mechanism. The court says that IBC is for insolvency resolution. Don't Not debt recovery. MSMEs cannot misuse IBC provisions to bypass traditional recovery mechanism like arbitration, MSME facilitation, councils, or civil suits. MSMEs must exhaust other remedies before moving to insolvency. Protection against misuse of insolvency process. Large corporate like PepsiCo benefit from the protection against tactical insolvency petitions, which could otherwise be used as a leverage by creditors. MSMEs should ensure their claims are valid and supported by proper documentation to avoid dismissal. Okay, what are the implications for MSMEs filing insolvency cases? Document payment and disputes carefully, including formal demand notices as MSME Act. Use the MSME Facilitation Council to resolve payment disputes before escalating to insolvency. Approach CRP as a last report when the corporate debtor is genuinely insolvent and unable to pay undisputed dues. Okay, so these are the implications. Okay, now see. There another important landmark judgment which we'll discuss in summary form, so we can understand easily. See here, there was a case between SL Mittal Private Limited, Satish Kumar Gupta. Okay. Interpretation of Section 29 AC regarding disqualification of promoters whose accounts are classified as NPA. So that was the issue. What was the judgment given? The Supreme Court held that promoters of companies with NPA accounts are ineligible to submit resolution plans unless the overdue amount are paid before submission. What was the conclusion? A significance established strict criteria for promoters disqualification under Section 29 AC, which was later laxed for MSMEs through Section 200. Okay. See here, that was the issue. Judgment given later on in IBC code as per Section 248, 290 AC, assumption given to MSMEs. Okay, so that was the landmark case. Another case was Sarvana Global Holding Private Limited versus Bafana Pharmaceuticals Limited. Whether promoters of MSMEs are eligible to submit resolution plans despite defaults. So that was the issue in this case. Judgment given by NCLT. NCLT held that Section 248 overrides Section 298 A, C, and H, allowing MSME promoters to submit resolution plans. Okay. Reinforced legislative intent to support MSMEs revival by permitted promoter-led restructuring. Okay, so that was the conclusion and that judgment was given. That was the issue. Another important case was, these are the major landmark cases which we are discussing in short form to understand how to treat the MSMEs under the IBC code. Another one was this here, Ramesh Camel Siemens Gamesha Renewable Power Private Limited. Applicability of Section 20A, 10A, Memorandum Moratorium during COVID-19 to MSMEs. The Supreme Court held that Section 10A applies universally and MSMEs are not exempt from the moratorium on initiating CRP for defaults occurring during the specific period. Clarified that MSME's classification does not provide exemption from the moratorium under Section 10. Means only exemption given under IBC Section 240A, 290A-C, 290A given. Other than this, there is no exemption given. For example, if 10A is applicable to everyone, so there is no exemption given for MSMEs regarding section as per section 10A for moratorium. So there is no exemption for MSMEs, special exemption for MSMEs. So that section is applicable to everyone, including MSME. Okay. There is another case. Mukul Kumar, RPS infrastructure. Okay. Whether MSMEs, promoters who are relaxed parties can submit resolution plans. NCLT held section 29ACH don't apply to MSME due to section 240A allowed related party promoters to submit resolution plans. Okay. Affirmed that MSME promoters, even if related parties are eligible to submit resolution plans under section 240. This is very important judgment. In normal or traditional CRP, related party cannot submit resolution plan. Okay, but for MSMEs under section 240A and 290A-C and 290H, okay, even if resolution applicant is a related party under section 240A, so that resolution applicant submit the resolution plan if registered under MSME. Okay, so that means that relaxation is given to MSME in case of even related party, the resolution applicant can submit the resolution plan. So that this is also very, very important judgment. Okay, from the understanding part of view, the resolution applicant, if in case of related party can submit resolution plan or not, so that is also very important. Okay, now coming to the another one. We are discussing so many cases here. Only there's 7 cases. Okay, now another one is Mukul Kumar versus RPS Infrastructure Limited. Whether MSME promoters who are related parties can submit resolution plan. Okay, we have discussed this thing. GNB Technologies India Private Limited, Vizag Chemicals, determining of MSME status for availing benefits under Section 240A. NCLT held that MSME classification must exist at the date of CRP initiation. Post facto attestation is not valid for availing benefits under Section 240A. Prevented misuse of backdated MSME registration to gain benefits under Section 240A. Okay, see, as per the judgment, NCLT that MSME classification must exist at the date of CRP. Post facto registration is not valid for availing benefits under Section 240A. So conclusion was given कि prevented misuse of back-end MSME session to gain benefit under Section 240A. But as per Supreme Court judgment, post CRP initiation also exemption is given to MSMEs. Okay, now another case was Joseph Churukulam Tea Estate Private Limited, eligibility of promoters to submit resolution plan under Section 240A. NCLT held that promoters of MSMEs are eligible to submit resolution plans even if they are related parties due to the non-applicability of Section 29AC, 29H under Section 40. Reinforce the applicability of Section 248 in allowing MSME promoters to participate in resolution process. Okay, there was only 2 sections provided to MSMEs which we have already discussed, 29A-C pertaining to NPA. Okay, but there is no other as per section provide particularly keys if there is a related party, but as per IBC code in that exemption of that benefit given to provided to MSME in case of related party also they can submit the resolution plan. Okay, committee of creditors SR Still, India Limited versus Sish Kumar Gupta, we have already discussed scope of judicial review over commercial decisions. The Supreme Court held that commercial decisions of the COC, including the distribution of the funds under a resolution plan, are not subject to judicial review, provided they comply with the provision of the IBC. Affirmed the primacy of the COC commercial wisdom in the resolution process, impacting MSMEs involved in CRP. Now coming to, as per above key judicial pronouncement, we have discussed what are the practical takeaways. Practical takeaways for MSMEs under IBC, promoter participation, MSMEs, promoters are permitted to submit resolution plans despite disqualification under section 29 AC, H, facilitating business continuity and revival. Number two, timely MSME registration. To avail benefits under section 248, MSME classification must be established at the time of CRP initiation. Post facto registration is not considered as valid. No. See here, this will be changed. Post facto registration means here this need to change. Post facto CRP registration is also considered now. Moratorium applicability. MSMEs are subject to the moratorium provisions under section 10A and cannot initiate CRP for defaults occurring during the specified COVID-19 period, pre-package. Okay, insolvency. MSME can opt the pre-package insolvency resolution process under section 54A, offering a faster and cost-effective resolution mechanism with the debtors in position, model, and creditors oversight. Means for MSMEs, there is a pre-package insolvency process under section 54 is covered under IBC. The time frame is 120 days. In traditional CRP is 330 days. Okay. And section 10 is applicable to, even also applicable to MSMEs. For timely registration of MSMEs, as per judgments, if registration is taken after CRP, is also eligible to get the benefit of benefit or exemptions benefit, but subject to the timeline of the resolution plan. If they have taken the registration before submission of resolution plan, so they can take the exemption or benefits. So these are the practical takeaways. Okay, now there was a question whether if MSME is giving payment to MSE not on time, then what will happen? The same criteria is available that MSME will be treated as a normal company. In case if don't get payment on time, so the same action can be taken by the supplier as normally taken against the other companies. Now, another topic is this managing hostile stakeholders under IBC. Okay, just give me a moment. Okay. See, managing hostile stakeholders under IBC. What it means? It means when any resolution applicant or when any financial creditor, when any other stakeholder is means hostiling the activities which is impacting to implement the resolution plan is called means hostile. But first we understand what are the objectives of the IBC. IBC was enacted to consolidate and amend laws relating to reorganization and insolvency resolution of corporate persons, partnerships, firms, and individuals in time-bound manner. Its core objective, maximization of value of assets of the corporate debtor, promoting entrepreneurship and availability of credit, balancing interest of all stakeholders, ensuring time-bound resolution of insolvency cases. Okay, 180 to 330 days under CIRP. Okay, what do you understand by hostile stakeholders? Hostile stakeholders is under the IBC refers to those stakeholders in CIRP or liquidation process who oppose, obstruct, or don't cooperate with the process of resolution plan or the insolvency professional. These stakeholders may act against the collective interest of creditors or the goals of the resolution, often to safeguard their resolution in their individual interests. Okay, means if any person is opposing or obstructing, or means for example, if management or director is not cooperating, okay, so then COC will face a lot of challenges because unless until they will get the information detail from directors, so then they will not be able to do CRP proceedings process. So if anyone who is opposing, obstructing, means creating any problem, if already approved by the financial director with 66% voting rights, okay, so that will be means everyone will have to accept, and according to that result, further action need to be taken. But what will happen in case if some of the persons are creating problem and not cooperating, so then the goal of the resolution will defeat. So then there is a certain measures we need to take, because ultimately the resolution professional is to complete the CRP proceeding within time frame. Okay. Again, we are discussing hostile stakeholders under the IBC code refers those stakeholders in CRP or liquidation process who oppose these stakeholders may act against the collective interests of creditors or the goals of resolution, often to safeguard their individual interests. Okay. Now, who can be hostile stakeholders? Hostile stakeholders are individuals or entities involved in the insolvency professional who act against the interests of collective resolution, either by non-cooperation or active obstruction. For example, management is not cooperating you. Okay, if and some of the person is creating problem and means handling. Okay, so then this is the case where when you are not getting any cooperation, that is one part. Another part is some of person stakeholders are obstructing. Okay, so that is means called hostile stakeholders. Stakeholder means who are having the interest. Hostile means they are means capturing. Okay, and they are doing they are influencing and doing control. They don't support the CRP and may use tactics to delay or derail it. Okay, the purpose of that stakeholder is if CRP may be delayed or derail it. Okay, these may include. Okay, we can categorize what are who can be the stakeholders. as per IBC code, promoters, dissenting financial guiders, operational guiders, shareholder or related parties, losing or disqualified resolution applicants, supplier or customers. For example, promoters or else as well directors seeking to retain control or avoid scrutiny. Okay, dissenting financial guiders opposing the resolution plan. As per resolution plan, approval required for 66%. Okay. In case if 33%, okay, are against that resolution plan, okay, if they are creating problem and opposing the resolution plan, so that is not fair as per the IBC code. If there is approval in COC meeting more than 60%, so then that decision will be applicable to all the stakeholders, including dissenting financial writer, operational writer, or and promoters and other stakeholders. And another hostile stakeholder may be operational writer, because operational writer feeling unfairly treated in the distribution mechanism, because approval is in COC meeting, only financial writer approval is required, operational writer approval is not required. They feel unfair in the, they feel ki we are treated unfair because we don't have we are not treating at par as financial writer. So that's why they also sometimes create problem or hindering the activities. Okay, another hostile stakeholders may be shareholders or related parties with vested interest. Another may be losing or disqualified resolution applicants. For example, resolution plan submitted by two companies, another two companies, some resolution plan submitted by 5 companies. Okay, only resolution plan approved one of the company. The another 4 applicant may be derail means oppose. Okay, so they can also means try to hostile COC. So that may be the one of the case of hostile stakeholders. Another case is supplier or customer involved in unavoidable transactions. Okay, so they can also be a hostile stakeholders. So these are the main categories categorized under the IBC. Who can be the who can be the person who can be hostile stakeholders. Okay, now how do hostile stakeholders hinder CIRP? They may employ several tactics. For example, see, earlier we discussed what is the meaning of hostile stakeholders, what is the objectivity of IBC, what is the meaning of hostile stakeholders, and who can be the stakeholders. But now question comes, how can they hostile? What are the tactics they adopt? Okay, see here. How can they hinder the CRP process? They may employ several tactics: litigation and legal obstructions, filing appeals, writs or repetitive applications before NCLT and Supreme Court. Okay. If they are filing so many cases, what will happen? Due to these legal obstructions or so many litigations, it directly impact on the CRP process, because when they will submit the litigations with any honorable court, the proceeding will start. Okay, and it will take time. So that time taken by these courts, honorable courts, it's means rise means increase the time limit of CRP. So that means due to the litigation and legal obstructions, they can hinder the CRP process. Another one, non-cooperation with resolution professional, denial of access to books, records, or assets of the corporate director. Okay, if director are not giving information, detail, as required under the IBC. Okay, and not providing the recourse or assets of the corporate debtor. This is also the case of the hinder of CRP process. Okay, unless and until resolution professional will get the detail and documents and assets under the IBC code, he will not be able to means complete this CRP process in time frame. And again, he will have to go to the COC or will go to NCLT for taking directions. So it takes time. In this way also means stakeholders hinder CRP process, delay in voting on resolution plans or objecting without valid grounds. Okay. If stakeholders in COC meeting note delaying in voting in resolution plans and also objecting without any valid grounds, that is also a difficult situation for RP. Because when you have a good resolution plan, okay, and without any reason, without any ground, okay, you are not means approving or taking time. So that means time frame in CRP will take more time. So that is also the case of the hinder of the CRP process. Challenging COC decisions, despite the Supreme Court emphasizing COC commercial wisdom. Okay. See, whatever decision taken by the COC will be applicable to all the stakeholders. And the court doesn't want to interfere in this decision taken by the COC, because as per honorable courts, they, as per their judgments, they emphasizing COC commercial wisdom. So they cannot means come into that part, because they, as per that is not the area where they can do anything. So means they believe on the COC decisions. That decision should be or will be or must be applicable to all the stakeholders. Okay, if some of the persons challenging COC decision and going to submit the petition in NCLT or NCLAT or Supreme Court, so that is also hindering the CRP process, because due to this time frame or time limit will increase that directly impact the CRP process. Disruption meeting or threatening other stakeholders, that is also the case of the hindering CRP. Attempts to siphon of assets or conduct fraudulent transactions, this is also creating problem and hindering the CRP process. In this situation, what will happen? RP will have to go to the court, okay, and ask for the directive, or then it will also take time, and that is also hindering the CRP process. Okay, now coming to this. See here, legal provision and remedies. See here, we have discussed how do hostile stakeholder hinder CRP. Now, what are the remedies? How can we resolve these issues? So there are certain sections and remedies available through legal provisions. With the help of these sections, we can take legal actions or using these sections. Okay, now we will discuss one by one. What are the legal provisions and remedies available in case of hindering or hostile stakeholders by the stakeholders? Section 19 mandates cooperation from management with RP. Non-compliance leads to imprisonment on fines. Okay, see section 19. As per section 19, if COC and management cooperation from management with RP non-compliance leads to imprisonment or fines. Okay, so management should cooperate to RP in case of non-compliance. So means means honorable court can take action under section 19 if there is problem from management side, if they are not cooperating with RP. Okay, and also there is a non-compliance. So then action can be taken against section 19. And in next slide, in detail, we discuss what are the consequences of non-compliance and what are the how much fine is there if management is not cooperating. If RP is going to the court and saying ki we are not getting cooperation from management and there is a non-compliance, if court think that is there is a non-compliance and management is not cooperating, so then action can be taken by the honorable court under section 19. There is another section 65, penalty for fraudulent or malicious initiation of insolvency proceedings. Okay. There is a penalty for fraudulent or malicious initiation of insolvency proceeding under section 65. We will discuss in detail. Section 70 penalize misconduct in CRP by officers of the corporate debtor. Section 29A disqualifies certain persons defaulting promoters from being resolution applicants. Rule 11 NCLT rules allows NCLT to pass necessary order to meet end of justice. See here, there are above 4 sections. See 29A we have already discussed above in detail. 1965-70 we will discuss. But rules 11 NCLT rules NCLT to pass any necessary orders to meet, and if there is a violation of these sections, RP can approach to the court and any other stakeholder can approach to the honorable court. So then NCLT will take appropriate action under the IBC code. See here. Measures to deal with hostile stakeholders. Empowering resolution professionals to seek timely directions from the adjudicating authority. Use of IBC panel provisions to deter non-cooperation of malicious actions, educating stakeholders about the collective natures of insolvency questions, strengthening COC role and protecting their decisions from unwarranted judicial interference. So these are the measures to deal with the hostile stakeholders. Okay. Now coming to judicial recognition of the problem. There was a case, SR Steel case. He found that COC commercial wisdom is supreme. Dissenting characters cannot stall a resolution if statutory process is followed. Means if statutory process is followed, so and on COC taken commercial decision, so that will be applicable to all the stakeholders. Okay, the dissenting characters cannot go to the court. Okay, dissenting characters can go to the court if there is a no statutory process followed. If there is a statutory process followed, in that case, dissenting character holder, the dissenting characters cannot go to the court. Another case, Swiss Ribbon versus Union of India. As a noted that the IBC is meant for revival, not for recovery, and must not be hindered by frivolous objections. Okay. Means IBC, his main objective is to revival of the business, not recovery. IBC doesn't want to prefer any company for a liquidation. IBC objective is to first revive the business. If there is no chance of revival, then in that case, the company have to go to liquidation. But IBC objective is not a recovery. IBC objective is revival. Okay, so that means a note must be hindered by frivolous objections. Okay, now see here. There is a judgment. In short, can we discuss the judgment? SR India Limited versus Tish Kumar Gupta. Background of the case: SR Limited was one of the first 12 large accounts referred to insolvency court by the RBI. It had a debt of 49,000 crore. CRP initiated under Section 7. COC approved the resolution plan with a payout of 42,000 crore to creditors. However, several operational creditors and Standard Chartered Bank challenged the plan on the grounds of discriminatory treatment of unfair distribution. Then what happened? SR Steel Limited versus Tish Kumar Gupta. NCLT modified the resolution plan and ordered equal distribution among all creditors, both financial and operational, which drastically altered the COC approval plan. Key legal issue before the Supreme Court. Can NCLAT, after the commercial decision of the COC on distribution of funds, should operation creditor be treated in par with financial creditor? Is the supremacy of the COC in approving resolution plan absolute? Was the SL Mittal takeover a hostile takeover or a legitimate resolution? Supreme Court resolution. Commercial without COC is supreme. Okay. Courts and tribunals cannot interfere the COC's decision regarding the distribution of proceeds unless it violates the provision of the IBC or manifestly arbitrarily. Number 2, equitable, not equal treatment. The court clarified that the financial and operational creditor need not to be treated equally, but must be treated equitably. Equitable treatment means fairness. Keeping in mind the different role of creditors, financial creditors have the expertise to evaluate viability, while operational creditors supply goods and services. Okay. Now, the court recognized that plan was approved by over 92% of the COC. Okay, so then promoter had tried to repay the debt after the resolution plan was approved, but court held IBC doesn't allow a promoter to regain control post CRP unless it is through legal eligibility and the binding process. Hostile takeover allegation by promoters. Promoter rules acquisition a hostile takeover, but the SC disagreed. The court clarified the entire IBC framework is designated to remove the management from defaulters and allow resolution by new parties. It doesn't recognize promoters' right once CRP begins, especially if they are disqualified under Section 29. Upholding SS Mittal's resolution plan. It allowed SS Mittals to acquire SR seal marking a landmark resolution for the highest recovery. Okay, what was the significance of the judgment? Strengthened the role of the autonomy of COC, clarified the non-equality but fairness principle among the creditors, discouraged interference by tribunals in commercial decision, set a precedent that the hostile takeover claims by the promoters are invalid once CRP begins under IBC, one of the most influential judgment in IBC jurisprudence. So that is very important judgment. What was the conclusion? The SR Steel case is a landmark judgment where the Supreme Court reinforced the sanctity of the CRP, the supremacy of the COC, and provide a clear rebuke to attempts by hostile stakeholders to derail or delay any insolvency procedure. It confirms the IBC is not a tool for defaulting promoters to regain control. Okay, but a transparent process for value maximization and revival. Okay, so that was the judgment given by the Honorable Supreme Court. Now there was another case. Okay, background. The petition challenged several key provisions of the IBC code. Differential treatment between operational financial creditor, exclusion of promoter resolution process section 29, power of the RP, time-bound nature, CRP, finality of commercial creditors, commercial decision. Key allegation, misuse, hostile stakeholder. IBC framework is being misused to effect hostile takeovers, promoters for submitting resolution plans, financial creditors to take control of the company, forcing liquidation or acquisition. These were the key allegations. Forcing liquidation or acquisition. These are the key resolution misuse of for hostile takeovers. The alleged scope for misuse of IBC for hostile takeovers. So that was the key allegations in this case. Now Supreme Court's detailed objective of the IBC is revival over liquidation. Okay, the IBC is not a recovery legislation but a revival and resolution mechanism. So that was Supreme Court's detailed observation. Number 1, objective of the IBC is revival over liquidation. The objective is not recovery. First objective is revival. Okay, the revival is means through as under the through the help of CRP. Okay, and recovery is done under the liquidation. The IBC first priority is to revival the business, not the recovery from the business. Section 29 exclusion for promoters justified. If in case of default at the end of the promoter, they cannot allow to participate or to submit the resolution plan. Except certain exemption is given to MSMEs, but normal circumstances, in case of a defaulter, promoter are not allowed to submit the resolution plans. So section 29 exclusion of promoters justified. So as per Supreme Court judgment, so section 29 is justified. Exclusion of promoters when they are in default. So petitioners contended that section 29A C disqualifying willful defaulter promoters from bidding was harsh and facilitated hostile takeover. SC upholding section 29 it ensures defaulting promoters cannot regain control of the company through the back doors. The intent to keep unsubstantial elements part of the resolution process. Section 29A protects the integrity and credibility of the IBC process. Okay, now third one was financial versus operational character. Different treatment upheld. Okay, because financial character can take means approved. The decision, if there is any decision is taken and approval given only by the financial character, not the operational character. So, as per this, financial and operational character are different, and there will be a different treatment for financial character, and financial character will be treated better than the operational character. Okay. Now, financial character are central to assessing viability and revival because they are more into the commercial side, so they can take the decision, commercial decision. Okay. Now coming to the series ribbons. Okay, the role of COC, their commercial wisdom is final. Okay, as per Supreme Court judgment, if any decision is taken by the COC, so that is the final and will be applicable to all the stakeholders. If statutory means procedure is followed, in case of it should not happen in case of dissenting characters. Okay, it cannot go to the court if due or statutory procedure is adopted. Okay. Protection against abuse of process. The court acknowledged that surveillance and malicious applications to initiate CRP cannot be penalized under section 65 of IBC. This is a safeguard against the misuse of the IBC is a tool for hostile takeovers or setting business schools. Okay. So what was the conclusion? These ribbons were a landmark body where the SC upheld the constitutionality of the IBC, protected the regulation framework from promoters' interference, reinforced the COC supremacy in commercial decisions, addressed concerns of misuse and hostile takeovers. Conducting the code has sufficient safeguards. Whatever the key takeovers on the hostile takeovers, the Supreme Court explicitly rejected the argument that IBC enables or encourages hostile takeovers. The code is designated to prevent backdoor entry of defaulting promoters, protect creditors, and ensure fair, transparent revival. That's why Section 299 is there. What is the conclusion? While the IBC is a landmark reform for resolving insolvency, hostile stakeholders remain a critical challenge. Their actions can significantly impair value maximization and delay resolution. Therefore, effective judicial intervention, cooperation among stakeholders, or strictly enforcement of IBC provisions are necessary to curb such hostility and realize the true spirit of the code. That is the conclusion. Okay, if you have any question, now we can discuss. There was one question asked by someone. If is there in case of any delay by MSME is in payment to MSME, then what will happen? I have the same treatment will be done means for against the MSME. So those if MSME do payment on time, so that will also be not means disallow under the Income Tax Act. Number one. Number two, we'll have to give the penalty or as an interest to the MSME. If someone have any question, we can ask. Otherwise, we will close the session. If there is any question, you can ask. Okay, if there is no question, we can close the session. Thanks a lot to everyone.
Sir, can we conclude now?
Yes, we can conclude.
Okay. Thank you very much, sir, for sharing your time and sharing your experience and thoughts about the topic treatment of MSME under IBC. Sir, you are requested to please share your presentation.
Okay. Thank you.
Participants, now there is lunch break till 3 p.m. New session will be started at 3 p.m.
Okay. Thank you.
Sit by 3 p.m. 3 o'clock.
Yes, 3 p.m.
Yeah. Thank you. Thank you.
introduction. I will maybe share my screen. Is my screen visible to all?
Yes, Neha, it's visible.
Right. So, as Anjali ma'am rightly pointed out, our topic for discussion today is best practices to deal with hostile stakeholders in insolvency proceedings. This topic itself is a very, very practical topic because there cannot be any, listed provisions or listed set of laws that you have to follow for the purpose of managing hostile stakeholders. Stakeholders are who? They are individuals, and managing individuals in itself is an art as well as a science. Therefore, there is no possibility of having any set guidelines as to how to manage stakeholders who turn hostile, whether it be CIRP, liquidation, or any other domain in relation to IBC proceedings. And therefore, for the purpose of today's discussion, I would suggest if we keep this in such a manner that it is more from the interactive point of view because we'll be sharing our experiences so far in handling IBC cases. What kind of hostility we had to encounter? What were the steps that we took uh, to address those hostility? And likewise, we would also like to understand from the IPs who are present in today's meeting as to what kind of what kind of experiences they had while handling several of the IBC matters. So, first of all, with respect to the outline for today's session, we'll be dealing about the general concerns in relation to insolvency proceedings, who can turn to be potential hostile stakeholders in the matter, impact of the hostility in the insolvency cases, and at last some of the judicial pronouncements in relation to such areas. So first of all, about the stakeholders as to who can turn hostile when it comes to insolvency proceedings. So broadly speaking, proceedings under IBC are divided into two halves. One is the CIRP and the other one is liquidation. When it comes to
Neha,
CIRP,
I'm sorry I'm interrupting in between, but some people have commented that the voice is not coming clear. If you can please check.
like, is it better now? Are you able to hear me now?
It's clear to me.
It's okay. It's
Others may
fine
please
actually.
confirm.
Yeah, it's fine. It's fine.
Yeah.
Okay.
Okay. Okay, so I'll move forward from here. So as I was saying, in IBC, proceedings can broadly be divided into two halves. One is the insolvency stage and the other one is the liquidation stage. In the insolvency stage, again there are two possibilities. If it leads to resolution, then an SRA comes into picture. And if there is no resolution per se or no plan is received, in that case, the company is shifted to liquidation. So let us first talk about the CIRP stage and thereafter we'll talk about liquidation. In CIRP, once again, for the purpose of initiating the proceedings, there are two possibilities. One is a creditor has filed an application, whether financial or operational, which has led to initiation of CIRP, or the corporator itself has filed an application under Section 10, which has eventually led to initiation of CIRP. So when it comes to the first scenario, that is when a creditor has filed an application, in those scenarios, practically what happens in 90% of the case, there is lot of hostility there is lot of hostility from the point of view of the ex-management and the ex-promoters of the corporate debtor. The reason it's quite simple because this is when a creditor files a CRP application, it is more so in the nature of a forceful insolvency. The dues of the creditors were not paid and therefore it led to filing of CRP application. And there are high chances of resistance from the ex-management, ex-promoters of the corporate debtor. On the contrary, when a Section 10 application is filed in those scenarios, because it was a well-planned, well-thought-of decision of the corporate debtor, in those scenarios, possibility of having resistance from management and directors is comparatively less as compared to the earlier scenario. However, we cannot say that there will be no resistance at all. Because in several of the cases, all the IPs present would also like to add here that in several of the cases, Section 10 is opted for the purpose of taking benefits of moratorium. So just to be on a safer side so that the secured traders do not take away the secured assets, sometimes as a strategic move, Section 10 application is filed either to delay the proceedings or to take benefit of the moratorium provisions under IBC. However, that is a separate tangent for discussion. Right now, we'll maybe stick to the hostility. Now, in the screen, as is quite visible, we have listed down certain kind of stakeholders who potentially turn hostile in almost all the cases. First is the ex-promoters, the suspended management, operational creditors, financial creditors, ex-workmen and employees, and other stakeholders, which could possibly be the statutory authorities at times, because in many cases, what happens, the claim of stat authorities does not come in the timely manner and which is submitted subsequently. And if it is filed after the last date, then an application is filed before NCLT for continuation of delay, which eventually delays the process even more. So that is one of the instances when even stat authorities can turn a little hostile in the insolvency matters. However, in general scenarios, this is broadly the list of stakeholders who turn hostile.
Neha, as you have rightly mentioned, that the role of stakeholders changes when the company is under CIRP and subsequently when the company went into liquidation. So when it comes to CIRP, there may be several stakeholders who become hostile, maybe because of their right is getting infringed, maybe because their right is not, they realize that ultimately the role that they used to play will not be there. Maybe because they think that they will not get anything once the company sleeps into the liquidation. So because of that, there may be several kind of stakeholders who become hostile. So the very first thing that the resolution professional faces when it comes to hostility is with respect to collation of information. Because mostly we have seen is what happens is the respective ex officials of the company, ex management of the company, ex promoters of the company do not provide the required cooperation to the resolution professional with respect to giving them documents, providing them information, connecting with them with the respective professionals who used to handle the earlier work of the company so as to give a detailed glance of the assets of the plant, etc. of the corporate debtor as the case may be. And the very first task that the resolution professional has is to collate the information about the assets as to what all assets are there for which I am required proper information in my hand so that I can sell that particular product. So say suppose in normal parlance as well, whenever we sell any product, we need to have the information about that product, everything in and out, so that accordingly we can advertise and accordingly we can gather good participants for the same, right? Good sellers for the same, or good buyers for the same, we can say. Similar cases here as well when it comes to CIRP process, when we are required to sell the assets of the corporate, or we are required to invite a proper resolution plan for the assets of the corporate debtor. So the first thing which is required to determine is what all assets are there, whether at all I have all the informations about the assets or not. And if I have not have the proper information, then who's the person who will provide me the information? The person who will provide me the information are the ex-officials of the company. And if they will not cooperate with me, if they will not provide the proper information to me, and if they will not provide the information to the respective SRAs who will submit their plan, so the entire process will become infructuous. I cannot put in money out of my own pocket. I cannot just bring in any information which is out of the box. So I have to see that whatever information I am providing therein is proper information, and for that I need proper cooperation from the ex-officials of the company. So the very first hostility that all the information, all the insolvency professionals, I believe, faces at the very first instance is from the ex-management of the company or ex-promoters of the company. But eventually, when they realize this thing, that if they are not going to cooperate, in that case, the resolution professional or the liquidator, as the case may be, they will file an application which will not have good repercussions, which will not have good results on their status. So having realized that particular position, they start providing the necessary cooperation to the corporate to the resolution professionals. As I know that you are going to discuss some of the cases wherein resolution professionals or liquidators have faces such kind of instances. They went to NCLT for the proper directions, and how NCLT have provided necessary cooperation, or how NCLTs have provided necessary guidance to the resolution professional as to how to deal with these kinds of issues. So the first hostility is with respect to the ex-management, ex-officials of the company. Then again, when it comes to hostility, then the most common hostility that RP particularly faces is with respect to the COC, Committee of Creditors. Because as you know, the role of Committee of Creditors is very much higher when it comes to CIRP process. What they used to do is they used to guide the resolution professionals to what to do. They run the process, they run the entire CIRP process. So that becomes at some point of time a bit hostile for the resolution professional, because resolution professional or IRP, as the case may be, they are not in a status or they are not in a position to do anything of their own until unless they are getting the requisite number of approval from the Committee of Creditors. Now, Committee of Creditors also comprises of the financial creditors only. So those who are not there in the Committee of Creditors also feel that fear of missing out. They feel that my concerns are not being addressed, my issues are not being addressed at the meeting, or whether at all I will get anything, what exactly they are deciding when it comes to resolution plan. They are not keeping in mind my interest when it comes to resolution plan. So these are the concerns which generally the operational creditors particularly have. So now this concept of operational creditors also we need to keep in mind that this concept of operational creditors is also till this CIRP process is running. Because this bifurcation between creditors of financial creditors and operational creditors is during CIRP only. And there is no more such bifurcation when the company slips into liquidation. Once the company is into liquidation, then the only bifurcation that remains within the creditors is with respect to secured or unsecured creditors. Then a creditor is either a secured creditor or unsecured creditor. And then the participation in SCC also changes. So in liquidation, there is a stakeholder consultation committee, and likewise the participation also changes. They also get a right to say when it comes to the companies in liquidation. However, of course, the role of COC and role of SCC is different, is quite different. One is authoritative, the other one is just kind of advisory. So there is a different role that they play, both the committees. So that kind of hostility from the creditors also the resolution professional faces. Then again, it becomes very difficult for the resolution professionals to make the respective creditors understand that how to submit your claim. What is the last day to submit the claim? What all informations are required to be mentioned when it comes to filing of claim to the creditors? How to file a proper claim such that your claim can be admitted by the respective resolution professional. Because most of the time what happens is some of the creditors do not even know that what they are filing. They just simply fill the form and send it to them. It is not only about filling the form. It is also about providing proper proof behind the claim that you are making. You cannot just randomly make any claim. You have to provide a proper proof behind the claim that you are providing, that this is the proof through which my claim has occurred. And in this way, I am filing this particular claim. So making this understand to the respective creditors. And if a particular creditor is not filing claim within the given timeline, then they will move to NCLT by filing this 42 application and frivolous application before the NCLT, several applications with respect to the claim. There are some occupiers. Sometimes we have seen that when there is a company which is dealing with or which is having some kind of property which have occupiers, which have tenants, in that case, again, it becomes very difficult to make those tenants, make those occupiers realize that your tenure with the company is over now. You cannot continue like a occupier anymore. So the resolution professional is required to realize this property, and therefore you are required to vacate this property. If at all you need that particular property, then you have to deal with the ultimate applicant separately, and you cannot just continue under the previous tenancy agreement like this. So there are several factors that requires consideration, that requires proper consideration by the resolution professionals, by the respective creditors, by the respective stakeholders, so as to make this entire process smooth, so that the entire process runs smoothly, right? Then again, it comes to what to do. So there are different kind of hostility, because there are all the cases under IBCs are different, all the stakeholders are different. You cannot just take one clue from one of the cases which is going on, that my case is similar to this. Your case may be similar, but there will be other factors which may influence your case, which may have different factors to see through. So you need to see as to what are the factors behind a particular case, what all factors require particular attention of yours, and if at all you see that a particular process which is going on is not as per the law, or if the requirements which are available in law is not within the purview or within the requirement, or it's not suiting your requirement, in that case the only gate which is open is the gate of NCLT. So you need to approach to the NCLT for the proper direction, so that NCLT can give you proper direction as to how to deal with that particular hostility. So this is a broad overview as to who all become hostile. Now, Neha, I would request you to deal with each and every hostile stakeholders as to who, at what point of time, what particular stakeholder will become hostile. There are relevant cases dealing with the same, wherein NCLT has provided certain relief to the resolution professionals or liquidator. Also, please deal with those cases as well. And what are the remedies available with respect to these hostility? If we can discuss that also in brief. And of course, simultaneously, if we can take the view of the participants as well, because participants here are mostly insolvency professionals and have also gone through with such kind of hostility and have also faces such kind of hostility practically as well. And given that IBC is completely on a practical base, so it will be interesting to have their views, to have their concerns as well, and to have their ideas as well with respect to dealing with this hostility. Neha, over to you.
Right, ma'am. So, as ma'am has rightly pointed out, at different scenarios, there are different kind of stakeholders who can turn hostile. So, starting off with the CIRP stage, CIRP initiates once the application is admitted by NCLT. In the order of CIRP, an interim resolution professional is also appointed, whose role is to collate all the claims and thereafter form the COC, Committee of Creditors. So the moment IRP is appointed, the first kind of difficulty or the resistance which an IP can face is at the time of collating the documents, collating the claims. There is a possibility that some of the creditors might not have submitted the documents, submitted the claim documents, and the management of the company is parallelly does not providing any books of accounts or the financials so as to give a picture of how much debt is outstanding as on the date of insolvency in the books of the corporate data concerned. So starting off with the promoters first, that at what scenario and why does the promoters of the corporate data turn hostile? So we have listed down certain reasons why an ex-promoter turns hostile. So I'll be taking up each of the pointers that we have noted down. First is the fear of loss of control or power. So what happens in case of insolvency, as we all are already aware of this thing, that once a plan is approved, the payment to all the liabilities that basically is wiped off basis the payment priority provided in the plan, which has to take into consideration the waterfall mechanism under Section 53. So this is in case of CIRP. In case of liquidation, what happens? The liquidator sells off the assets or realizes the assets of the corporator in the and distributes the proceeds in the manner provided in Section 53, that is the waterfall mechanism. And in both the scenarios, it is the shareholders, the equity shareholders, who gets the last priority rather, and therefore there is no hope of any realization when it comes to equity shareholders in case of CIRP or liquidation. And that is why the foremost concern of the promoters is the loss of control, the loss of power that they have in the corporate data before it slipped into IBC. And therefore, because of this fear, they become little reluctant in sharing the information and hence turn hostile. Next could be the reason of fear, the fear of investigation and liability, as IBC mandates or put a mandate on the resolution professional or liquidator to analyze for avoidance transaction. avoidance transaction, which includes preferential transaction, undervalued transaction, fraudulent transactions, or extortionate grade transactions. So these 4 transactions, popularly known as PUFA or PUFA transactions. So it is the duty of the resolution professional or the liquidator to do the proper audit, to the proper forensic audits and transaction audits, so as to identify the PUFA transactions. And therefore, there is a fear in the minds of the management that in case such transaction have had happened uh, in the corporate data, then there might come a picture where they are under the obligation to bring in funds to satisfy to nullify the effect of the avoidance transactions. Third reason could be financial stake and personal guarantees. In several of the cases, what happens, the for the loans or for the loans taken by the corporate debtor, personal guarantee is extended by the promoters of that corporate debtor. So, in case the company slips into insolvency, it comes into the light. It comes into light that might lead to a situation where all the creditors are coming up might come up against the personal guarantor so as to realize their funds. Because there's a fear that if the company has slipped into insolvency, I might not be able to realize anything that I might otherwise have realized, and therefore the financial stake of the corporate of the promoter co- comes at risk. Fourth reason could be the desire to regain control over the corporate debtor. People might have perception that if they create hindrances in the process, it might lead to them getting control over the corporate data once again. And therefore, they might use some delay tactics or create obstructions in the way of RP doing the performing his role as a resolution professional. Next reason could be ineligibility under Section 29A. Section 29A of IBC deals with the applicants who are not eligible to submit the resolution plan during CIRP or acquire assets under liquidation. So they are ineligible under both CIRP as well as liquidation. So to get a backdoor entry into the company again, they might create such situations that not directly but indirectly or through a backdoor, they would want to get entry into the corporate debtor again. So these are the possible reasons why the ex-promoters becomes hostile when it comes to corporate data. And the prime way of creating hindrances is by not providing access to the documents, not allowing entry into the premises, not providing proper documents to do the scrutiny of what is the position. Say, for example, a corporator has several of the plants or the factories, then not allowing the RP to enter the premises to check what is the situation, what kind of assets are there in the property concerned. And therefore, in several of the cases, we've also seen that they become so hostile that they send goons or use weapons on the resolution professional. So in such scenario, what does a resolution professional will do if he is not getting the required cooperation from the ex promoters or ex management? In that case, Section 19 of the IBC deals with such scenario where there is non-cooperation or there is hindrances on the way of the RP in doing the CIRP proceedings. If any such scenario arise, in that case, the resolution professional has all the authority to make an application to the NCLT, praying for the desired reliefs, which could be, if the case are very extreme, then police support for the purpose of gaining entry into the premises of the corporate debtor. So police support is generally extended in very extreme cases. Generally, NCLT give directions to the promoters and management to supply all such documents as the resolution professional requires for the purpose of conducting CIRP in a successful manner.
Now, there may also be one of the cases wherein, the company, say suppose the company is a listed company and the company is holding investments in other companies as well. And the ex-promoters of the companies are maybe there in a company in which the company used to hold investments as a nominee director. Now, once the process starts, after that, what I'm required to do is I'm required to change the nominees such that I can appoint my nominees. Accordingly, I'm also required to see if there is any joint venture agreement or any SHA entered into by and between these companies with respect to nomination, etc. So what these ex-promoters do is they do not provide the details with respect to SHA or joint venture agreement. And again, they do not want to vacate their office as nominee directors in the other company. So that is also one of the positions that is also one of the way wherein, the professionals faces this difficulty when it comes to taking proper cooperation from the ex-promoters of the company. And also, there is one situation wherein, say, suppose the company was one of the promoters of one of the listed companies, and that listed company, say, suppose the trading of that particular company has stopped for some or other reason. So as per the BSE and NSE's internal circular, the PAN of all the promoters will get freeze. So because that particular company in which I used to hold investment is no more able to trade or no more able to execute trading, being a promoter of that company, my PAN will also get freezed. So the moment my PAN is getting freezed, I'll not be able to make any transfer of the investments, because investments are also one of my assets and I'm required to realize those assets. Now, because the shares are freezed, I'll not be able to realize that particular asset because I'll not be able to transfer those assets to anybody. So here we have also seen that in some cases, the liquidators or the resolution professionals are required to pay dues for those companies in which the company used to hold investment, so as to make this path clean, so that to realize these investments, to make this transfer smooth. So these are also a kind of hostility only that the company or the respective resolution professionals and liquidator, as the case may be, have faces when it comes to CIRP or liquidation case.
Right, so not a direct hostility, but an indirect hostility by not
Yes.
paying the fees of that listed company, the listing fees for that company, of which the corporate debtor is a promoter.
Absolutely.
And thereby, pursuant to which the PAN of the corporate debtor is also getting freeze, which is creating hindrance in realizing the assets which are listed. Not just of that company which has not paid the dues, but of any other company in which the corporate debtor is holding stake.
Yes.
So this is another case where there is no direct hostility, but an indirect hindrance in the way of the RP.
And the thing is that nothing in this regard is provided in law. So if you need a resort in law, then law does not specify for these kind of cases, because these all are case specific. Everything differs from case to case basis. So nothing is provided in law in this regard. So what is required to be done? Either to have mutual discussion with the ex-promoters so that they can provide the cooperation. If at all the resolution professionals or the liquidator, as the case may be, they realize that there is no chance of having a proper communication or there is no chance to resolve this issue, then the way to come out of with these issues are either to file an application with NCLT to get proper direction, or to move to IBBI, because IBBI is the governing authority who's the complete watchdog for the entire process, to take necessary advisory and to ask for necessary interference by the IBBI as and when required with respect to the
Under which
cases.
section?
Right?
Under which section RP can go to IBBI?
Section 19, sir, Section 19 when it comes to
To
CIRP.
IBBI. To IBBI.
There is no section per se for the purpose of reaching out to IBBI, but there are specific mail IDs wherein you can put your grievances, and the respective team of the IBBI which looks into CIRP and liquidation gets into touch with you.
So there is a
any
grievance
instances?
redressal portal by IBBI, sir. Whenever you are facing any concerns with respect to the process that you are following, or with respect to the cases in which you have been appointed as a RP or liquidator, as the case may be, then of course that door of IBBI is open for you, because IBBI is a watchdog for the entire process. The moment you are doing anything wrong, IBBI will come up and will ask you as to why you have not performed a particular duty. So at the same time, when you are facing any hindrance in performing your duty, then that door of IBPI is always open for you to go and to ask for necessary interferences and when required. So while again, as I said, everything is not provided in law. This is again based on the practical difficulties only.
No. My question is, ma'am, where does the IBBI get the power to interfere with the corporate debtor in the process?
IBBI has?
Through which law or through which act, which regulations IBBN can ask the promoters or the ex-management?
Whilst the IBBI may not ask directly to the promoters to provide the cooperation, however, IBBI may move to the respective courts to provide the application. You may also have seen certain cases wherein IBBI have moved application before the respective courts to in the cases wherein the ex-promoters have not provided cooperation to the resolution professional or liquidator?
Only court in this process is the NCLT.
Not
Because you
directly by
can only
NCLT,
take
sir.
or
Not directly by
only take
NCLT. There have been cases wherein civil IBBI has also approached civil court for the proper guidance.
Those are related
Can
to investigations and all, I think.
those were the investigation cases, not to
Yes,
non-cooperation of the
not in general.
non-cooperation of the corporate debtor. I think the proper channel is the NCLT, ma'am. I think so.
I'll give you reference of one of our own cases, sir, while I'm not authorized to do so, but I'll give the reference of one of our own cases. So it is a case of Bajora Steel Rerolling Mills Private Limited. This is the case wherein liquidation process of the company was completed in 2019 itself. However, that company was under CIRP in 2018, and ultimately because of non-cooperation of the ex-promoters of the company slips into liquidation process. So what happened at that point of time is the NCLT order that particular directed for the liquidation process of the company captured this fact that ex-promoters and ex-directors of the company have not cooperated with the liquidator or with the resolution professional, because of which the company slips into the liquidation. That particular point was also cast by the IBBI, and IBBI has initiated proceeding before the civil court. That proceeding is still pending. While the company is liquidated in 2019 itself, but the proceeding is still pending. So there is a public prosecutor appointed for that case, and the matter is being initiated by IBBI only.
No, actually, can I come in?
Yes,
See,
sir, please.
in the situation that you are talking about, nowadays the IBBI is asking for information on a monthly basis in terms of which are the cases pending beyond 180 days and 270 days. And that is where, NCLT is intervening in terms, or IBBI is intervening with NCLT in terms of expediting those cases for closure or completion of CRP or the liquidation. But in any other case or any grievance that you go to IBBI with, they will typically tell you to approach NCLT.
While, sir, yes, you are correct that these days IBBI is also referring to NCLT only, because they are saying that under section 60, NCLT holds the sole jurisdiction to entertain the cases when it comes to cases connected to the corporate debtor. However, when it comes to non-cooperation, when it comes to not providing the proper facilities to the resolution professional as were required, there have been several cases wherein IBBI had initiated cases in the past. In recent days, I do agree with you that in recent days, IBBI is also asking the respective resolution professionals to move to NCLT only, or to initiate necessary proceeding before the NCLT. In fact, on one hand, they are trying to reduce the burden of the respective resolution professional, that respective NCLT, such that the cases of relating to IBCs can be expedited. But at the same time, they are also asking the resolution professionals to move to NCLT when it comes to this kind of non-cooperation. I do agree with you on this point.
Problem is that what NCLT says, it says that what you have done, why you are hiding behind 19.2. What step you have taken? So what are those steps that should have been taken by the RP or liquidator?
So say you are a resolution professional or you are a liquidator. To what extent you can go to have the proper information in hand? You can go to the public documents which are available. You can go to the ex-promoters, ex-employees, ex-management of the company to gather those information. So these are limited resources through which you can gather the information about the corporate data. You cannot go beyond that. So even in case of private limited companies where the sources are again very limited, there again you have to rely for this limited sources only. While in case of listed company, there are several information that you will get otherwise as well. But for private limited company who do not even maintain their proper registered office, it becomes very difficult for the resolution professionals to gather information. So they need cooperation of the ex-management or the ex-promoters of the company to continue with the process further. So the moment this question arises as to what you have done, the best what the resolution professional can do is to send mails, is to send letters, is to ask the respective ex-directors or ex-promoters of the company to provide necessary cooperation, to ask the employees who at all are there, or to bank officials, or also to the financial creditors. Because ultimately it is the financial creditors or operational creditors who have filed the claim. So they must have certain kind of connection in the past with the ex-promoters, ex-officials of the corporate debtor, to ask them to support or to ask them to provide the information to the extent the informations are available. Because financial creditors are, again, they have lended money. They cannot just see the faces of the promoters and lend the money. They must have seen certain financial background of that particular company, and based on that they have extended the money to the respective company. So they must have those financial information. They must have kept some track with respect to the performance of the company. So those financial creditors are also duty bound to provide the necessary information to the resolution professionals or the liquidator, as the case may be, such that the process can run. Now, this 19.2, where what you have done, what best RPs can do, they are required to perform those tasks. Now, you cannot just sit idle and can say ki, they are not providing the proper information to me, or they are not cooperating with me. So you need to ensure that you have done your task, you have performed your duty, you have done to the extent was possible for you to gather the information. However, at the end, when you could not get the proper information, then you are left with no other option than going to the NCLT for proper resort.
Oh, no, but
Actually,
NCLT is not satisfied with this. Actually, most of the RP do this. They always does this. But this is what else you have done. Means you have shoot so many emails and all that. But that is not suffice. So whether you go to superintendent of police and all that.
like, can I come in on this?
Yes,
Actually,
sir, yes, sir,
I
please
got a
continue,
guidance.
sir.
I got a guidance on this very nicely from a NCLT bench, because like, the same situation that, I was wanting to get the data on the information memorandum, which is right at the outset of the CRP. Now, I was not getting information, including the financials, and being a private limited company, obviously you are not having any public sources for data. Now, so we had provided, so when we went to NCLT under section 19, so judge was very irritated. Said, why you keep coming to NCLT for small case, for every small thing? You should first, as he mentioned, as one of you mentioned, what have you done? So, thankfully, and second is, don't come to me for he's not cooperating in a general sense. You tell 1, 2, 3, 4 specific areas of non-cooperation. Thankfully, we were able to demonstrate a list of all the information that we needed. What is the follow-up that we have done? What is the public sources that we have till now accessed and got information? What is information pending? And also all the documentary in terms of, the meetings done, emails sent, all that we were able to demonstrate. So we got a very specific order in favor. And so this guidance, thankfully I got this in the very, early days of my RP. So I've been religiously following this in my cases. So your question, what RP should do, he should demonstrate whatever he has done, document everything, and be specific as far as the plea is concerned under section 19, rather than giving a blue sky general plea that there is non-cooperation. I think that will at least convince NCLTs in terms of protecting you and enabling information.
Absolutely, sir. As I said, that you cannot just sit idle and ask NCLT to support you, that they are not giving the information. I have showed 3-4 mails and they are not providing information. You cannot just say that. First, you are also required to understand as to what information you are needed. So you need to prepare the particular list of informations that are required. Then you have to see as to what all information you can get otherwise as well. And you don't have to rely upon the ex-management, ex-officials of the company for those informations. Like some of the informations you can get from the financial creators, some you can get from the bank, some informations can be publicly available. So you have to tick out all those informations which are otherwise available and are not required intervention from the ex-management, ex-officials of the company. However, still if there are certain crucial informations which are pending and which cannot be provided by anybody else apart from the ex-management, ex-officials of the company, in that case, you need to again send 2-3 mails and follow-up reminders, follow up in the mail ID or in the informations to the last available mail ID and the address which are available with you. So send those letters, collate the proper documents with you that you have done to the best you could for the purpose of gathering information. However, at the end, since you are not getting the informations which are required, which are crucial for the purpose of the continuation of the CRP process, then only you can approach the NCLT that I have done my job, and since I'm not getting the proper information, hence I have come to you for the proper direction. So of course, this
And
kind of approach is required. There have been several
yeah, and
cases which have slept into liquidation because of non-cooperation, which have ultimately dissolved by the NCLT because of non-cooperation, because there were no other way to collect any information. There were no employees, no registered office, nothing. Everything was frivolous. So these are also there have been instances with respect to these as well. So that again, as I said, it varies from case to case, and again it varies from NCLT benches to NCLT bench, because all the judges have different views. Some of the NCLT benches have taken this view that what you have done or what steps you have taken show that, and don't come to us on every now and then. Some benches again have taken this view that the moment you are not getting information, why you have not come to us earlier, why you are coming at this stage, you should have come to us earlier, why you have wasted this much of time when you know that IBC is a time bound process. So it depends from case to case, it depends from judge to judge. That is what I can say.
no, one more additional thing is, when we were able to demonstrate whatever we have done, the judge not only he did not dispose of the case. Thankfully for us, because the list of pending information was quite long, he actually he gave a date and continued until all the information was provided. So that was a good part. Thankfully, that bench became very, useful for us. But this should become a plea for in the section 19 also. Okay, the matter not be disposed of until entire information as required is provided. So that is something that RP should include in their applications.
Absolutely, sir. Absolutely. Yes, Neha, you may continue further.
Right, ma'am. So, next, maybe as we have already discussed about what all measures can the RP do so as to make a case that they actually tried getting all the documents, however, was not given any cooperation from the ex promoters, ex management. So, we have listed down some of the cases. I believe there are several of the cases. However, we have pointed out some of the well-known rulings in the context of some of the rulings wherein hostility was seen from the promoters and what directions NCLT benches have given. So first is Sailesh Chawla and another versus Vinod Mahajan, wherein the promoters were not provided the required assistance in managing the affairs of the corporate data, wherein NCLAT held, as is very much clear on the left side of my screen, that section 19 of the code latently and patently imposes an obligation on the personnel of the promoters of the corporate data to extend all the assistance and cooperation which the RP will require in running or managing the affairs of the corporate data. In this particular case, it was a very clear-cut direction from NCLT from NCLAT to provide the required assistance to the resolution professional. Likewise, in the next scenario, what happened? The ex-promoters of the corporator threatened the IRP against entering the premises, and which eventually led to unreasonable delay in the process. In this case, Punjab National Bank versus Divya Jyoti, police support was extended to IRP. So when we started this particular session, the opening statements were such that all the cases in IBC are different from each other. There could be different kind of hostility, different kind of hindrances in different cases. So the cases which we are discussing right now is merely the examples of what kind of hostilities the IPs had experienced in their matters. Third case, which is of Vishal Kalantari versus Shailen Shah, there was unnecessary litigation by the erstwhile promoters so as to delay the order and to frustrate the resolution professional, because as we see that CIRP is a time-bound process, and the moment several of the frivolous applications are filed, it actually takes the time of NCLT in adjudicating those cases and thereby causing unnecessary delay in the process. So this was another situation. Next, in case of Arun Kumar Jagtramka versus Jindal Steel, the promoters tried to take control of the company back by using backdoor entry. So regarding backdoor entry, they kind of put in the applicants wherein the money was indirectly supplied to the same promoter because they themselves were directly ineligible under Section 29A because of being the promoters of the corporate debtor. They took the backdoor entry, which ultimately took time of the resolution professional in verifying whether the applicant concern is eligible or not, which ultimately led to delay in the process, obviously. And in most of the cases, the thing which has remained common is delay in the process because IBC, by its very nature, is a law that provides for time-bound mechanism, time-bound processes for dealing with CIRP and liquidation cases, and all these hindrances with the promoters or any of the stakeholders create, they eventually lead to delaying the process. Next, coming to the S. Mutturaju case, wherein the liquidator was restricted from entering the premises of the corporate debtor, and a group or mob of unknown person huddled and threatened the RP using weapons and did not allow the IP to enter and function as the liquidator. In this case, again, NCLT provided required police support for the purpose of gaining entry into the premises and for concluding the liquidation of the corporate debtor concerned. So these are some of the famous cases which we have taken out for the purpose of discussion, wherein the promoters have turned hostile in the insolvency cases.
I would like to suggest, I would like to give one case where
Yes, sir.
this in this promoter issue, the promoter was not helping IRP to take control, okay, in the factory premises, and they were threatening. So IRP eventually filed the 19(2) applications, and when he appeared before the NCLT, NCLT appointed a court commissioner to take control along with the IRP basically. So IRP along with the court commissioner went to the particular premises of the corporator, and then and it was a fully authorized. They have the court NCLT have already fully authorized the court commissioner to take all type of helps to give possession of the premises to the RP. So this is also one of the help which NCLT can provide to take control of assets where you definitely know that this is the premises which is uh, in the name of IRP, in the name of the CD.
Right, sir.
I was also seeing some of the cases initiated by IBBI under Section 236 of IBC, that IBBI has initiated cases before special court with respect to non-cooperation. There have been certain cases in IBBI's website as well in this regard, wherein IBBI has initiated cases for the non-cooperation by the ex-promoters of the company. Yes, Neha.
The one which we were discussing some time back, that what actions IBBI can take for the purpose in cases where there is non-cooperation from the part of the
Yes.
promoter's management.
Yes, correct.
Right. So this was about the hostility from promoters end. We are moving ahead to the next segment, that is the suspended management. So here again, we have listed on certain situations which can lead to the ex-management becoming hostile when it comes to insolvency proceedings. First is once again loss of power and status. Management includes the directors, the top officials of the company, and the moment company slips into CIRP, all the rights and powers comes in the hands of the IP who is so appointed, and therefore they might come into a situation where they are not able to exercise any of the powers which they were previously able to exercise. So this kind of situation in IBC can lead to creation of negativity in the minds of the ex-management and thereby leading to creating hindrances in the way of the resolution professional. Next would be the lack of trust and communication breakdown, that they do not provide the required information, as we have been discussing from the very beginning, that they are not providing the required documents, they are not providing the required information for the collation of documents, and preparing the information memorandum for the for the resolution professional becomes a challenge in that scenario. So these are the cases when there is ongoing CIRP, that they're not providing information, that they're not letting us enter the premises. But what happens when the resolution is successful and leads to an SRA coming into picture? So CIRP results in two outcomes. One is either resolution or liquidation. When there is successful resolution, an SRA comes into picture who takes control of the corporate debtor. In such scenarios, what happens? Like I'll be sharing one of the cases. For example, the corporate debtor concerned had a plant in some kind of village wherein there was some private electricity supplier who was supplying all the electricity to this factory of the corporate debtor. This corporator slipped into insolvency, and all the past electricity dues were pending to be settled by the corporate debtor before it went into CIRP. When the resolution professional was inviting claims from the creditors, whether be financial creditor or operational creditor or other creditors, at that time, this particular private electricity supplier did not file its claim with the hope that this company is presently under CIRP. Once the plan will be approved, then there will be deep haircuts leading to very less recovery of the outstanding dues. So let us do this thing that whenever this property will be sold off and another occupier will come in, we will not provide electricity to this new occupier till all the past dues are paid off. So this kind of non-cooperation from the point of view of the other stakeholders like electricity supplier can also come into picture in the context of a context of resolution applicant. From the point of view of the management, what can happen? So the resolution professional liquidator in the sale documents, they write that they are selling off the asset on an as is, where is, whatever there is a no recourse basis. That whatever information me being an IP has, I have provided you everything, but I am selling off this property with the way it is, and I have no comments, no remarks on whether it is good, bad, or howsoever it is. You can do your own diligence, you can do your own scrutiny to identify if it is fit for your investment or not. So for that purpose, say I am sitting in Kolkata today, I am the liquidator of a particular company. The property is located in somewhere in South India. So the resolution applicant, when it go for its scrutiny or for its diligence of the property, at that time what can happen? The entry is not provided to the resolution applicant, thereby leading to the failure of proper diligence or proper scrutiny. And eventually there might be a scenario that the resolution applicant is no longer interested in submitting the plan for the purpose of revival, given that when it given that it is facing so much of hindrances at the stage of diligence. So what will be the scenario when he actually becomes the occupier of that property? So this kind of hindrances can also lead to very less recovery and ultimately frustrate the entire process. So these are some of the reasons why the management becomes hostile. Now let us look at the cases in this context. We have once again put in some of the relevant cases wherein the suspended management had become hostile. So first case is Ashwin Mehra, wherein the management of corporator failed to grant access to RP with the list of assets and the block of accounts, etc., and the book of accounts, etc., leading to failure in preparation of the information memorandum and everything. NCLT in this case, the RP moved to the NCLT, and NCLT had given directions for the purpose of directions for the ex-management to provide the necessary support to the resolution professional. Likewise, in Vigisun Exports, neither the cooperator neither handed over the possession of the assets nor the records during the material period, even after passing of the liquidation order. So during CIRP, they didn't provide any cooperation. The company slipped into liquidation. Even in the liquidation stage, there was no cooperation at all. Then it was presumed that the erstwhile directors of the cooperator had deliberately stolen records with an intention to enrich themselves and also to siphon off all the assets without even bringing to the knowledge of liquidator. Therefore, the attitude or the steps taken by the directors themselves were very, very malafide in this particular case. And the prime reason, what I understand, could be the fear of avoidance transaction, that they do not provide documents so as to ensure that their bad deeds or their evil deeds in the past which will qualify as a POFE transaction do not come into surface, because that might lead to them providing the funds into the cooperative. Next is the case of asset reconstruction company versus Shivam Water traders, wherein the cooperator did not hand over the required documents and information to the resolution professional, and one of the ex-directors abused the RP and created hindrances in the CRP process. So mostly the scenario with respect to the kind of hindrances is more or less the same, that they are not providing entry, they are not providing information, they are not providing required documents. So this is with respect to hostility from the suspended management. At this stage, if any of the participants would like to share their experiences, in addition to what we've already discussed, like other than the reasons or other than the cases that we have discussed where the ex-management or ex-promoters have turned hostile, there are some other cases if someone would like to add as well.
See, before you go to all the NCLT, you have to, as RP, you are ultimately managing a company. You have to take decisions and you have to implement them rather than running to NCLT every time. I have a case where, we were running a company and there was this HR manager who was the, let's put it this way, the class admi of the erstwhile promoter or the suspended promoter and board. So he used to call the shots. So when as RP, I had to make changes in terms of the organization structure and, get responsibilities reassigned and, shifted from one set of people to another, no instructions would go and things remained the same. So in spite of multiple, conversations and emails, of course, we have to keep record of all the communication that has gone. But then I had to see to it that that person was thrown out of the company. If he's creating a hindrance in terms of actual management of the company and not allowing, people to function, he had to be told to leave. So, I mean, ultimately, that ex-promoter must have also stepped in and, reassigned him to some other group company or anything, but that is a different issue. But ultimately, as RP, you have to take decisions on your own. And sometimes, NCLT becomes too slow a process for you to, because sometimes, companies, when you're running, you have to take decisions on a daily basis. And
Right. So
NCLT becomes a very slow mechanism for you to achieve results.
yeah, so basically, as a resolution professional during CIRP, the IP should be very cautious about the erstwhile staff whom they are retaining for the purpose of managing the affairs of the corporate debtor. So this also becomes a very important checkpoint, that who all are you retaining or what kind of staff you're retaining for the day-to-day management of the corporate debtor. So very rightly put also. So next we are moving on to the financial creditors. So this particular stage was when the IRP is collating the information, preparing the list of creditors, and eventually forming the COC. Now, when it comes to financial creditor, as Barsha had rightly put in, that the difference between the type of creditor, that is financial creditors and operational creditors, is relevant only till the CIRP stage. Once the company slips into liquidation, the bifurcation between whether the creditor is financial or operational has no relevance, and everything is basis the secured creditors and unsecured creditors. In case of CRP, as we all know that all the financial creditors, they form part of the COC, and depending upon the size of the claim, their voting rights is also bifurcated in the COC meetings. So say for example, there is one financial creditor which is holding 90% stake, and there are several small financial creditors who, although are part of financial of the COC, however, are able to exercise very less. Uh, I mean, when it comes to, because for the purpose of approving a resolution plan, a majority of 66% is required. Therefore, in any case, whatever they are saying is just the words and is not required to be implemented, given that they are the minority in the COC. Therefore, the reason why financial creditors becomes hostile, once again, we have put up some of the scenarios. First is disagreement on the resolution strategy. If there are three people sitting on the table, all three of them might have different perspective, different resolution mechanisms. Therefore, there might be a scenario where all the three of the COC members, they are in complete disagreement to what the other people are saying. And therefore, this might create a hindrance in proper decision making because no one is coming on to a particular decision. Next reason could be is power dynamics within COC SEC. Like I am a superior creditor, I will do whatever I wish to do. I will because I am holding 90% or I am holding the requisite majority of stake in the COC. My decision would prevail. So this kind of power dynamics can also be a reason that the other creditors might turn hostile. Then fear of inadequate recovery, because in case of IBC matters, the haircuts are really deep. So there is always a fear that if the resolution plan does not provide for such amount of funds that I am to suffer a loss which is completely unbearable. So this kind of fear might also arise in case of in case of financial creditors who are CUC members. And at this stage, I would also like to talk about one of the cases in the matter of PSP Udyog. It was a Supreme Court matter, wherein one of the financial creditors who was also secured in nature, pursuant to the plan, his recovery was say X amount, say 100 rupees. But because that particular creditor is a secured creditor, if the company slips into liquidation, its realization during liquidation pursuant to sale of the underlying asset would be more than 100 rupees, which it is getting in CIRP. So maybe I'll come again. During CIRP, pursuant to the plan, say my recovery is just 100 rupees. I'm a secured financial creditor. But if the company slips into liquidation, even if I take resort to section 52, which talks about realizing the asset outside the liquidation estate, in that case, after realizing from the underlying asset, say my recovery would be 110 rupees. So what I would prefer that the company goes into liquidation because at that stage my recovery would be more than what I'm getting in CIRP. So this kind of situation also creates hindrances in approval of the resolution plan because they will always want that this particular plan does not get approved and the company eventually goes into liquidation. Next would be lack of transparency or consultation.
You rightly said that there's a non-cooperation there may be a non-cooperation from the creditor itself. So
Right.
in that case, what RP is supposed to do? See, they have a very, you may say, undue power to replacing the RP at any stage of the CIRP.
So sir, there is
Suppose, see, I am not saying that RP should not do, but you are getting my point.
I got your question, sir.
You are getting
So
my point. Either the corporate data is not cooperating, that is the reason for delaying the process, or the committee of creditor or particularly financial creditor are not cooperating, or they are not approving the plan, or they are kept hanging the plan, revising Form G 3 times, 4 times. They may be the reason. So in first case, corporate data is not cooperating. We are very much clear that what we have to do 1, 2, 3, 4, and go to the NCLT, go to the IBBI. But suppose in any case, if the FC is not cooperating, or there are chances the FC are making a hindrance in the process, what the RP is supposed to do? Just asking what the RP is supposed to do in that case.
So, sir, in this scenario, the case which I had framed, wherein the financial creditors were wanting the company to slip into liquidation. So, there is a saying in case of IBC that no one can sit on the commercial wisdom of the COC members. So, if their commercial wisdom says so that CIRP is not the right forum and the company should slip into liquidation, in such scenarios, RP has no say because RP is driven by the decision making of the COC members. So in such scenarios, particularly the resolution professional has not a lot to do. It's just that the resolution professional can put up his view that this is not correct or that is not correct, but the ultimate decision making lies with the COC member. So
Supreme Court judgment is there. So what RP is
right.
supposed to do in that case? You correctly said in liquidation they get maybe 105% or even extra 1%. They happily go to the liquidation because they have the voting rights. However, in the liquidation they lose some of their voting rights, but still they are the biggest financial creditors. So they look, see, we are the resolutions in the liquidation. The resolution applicant may or may not come because they are also liability increasing in the liquidation, not in the CIRP. So see, I can't comment on the commercial wisdom, so you can't answer.
Right. As Max, you can basically advise the use members that this is the picture, that will be the picture. You are assuming that you will get better recoveries, but that might not be the case because liquidation depletes the value of the underlying asset. Ultimately, liquidation leads to depletion. Therefore, at max, you can advise, but no one can sit on the commercial wisdom of the CUC members. So ultimately, it is CUC's call as to what they would want to proceed with. Right. So this is the case of financial creditors. Next, when it comes to operational creditors. So role of operational creditor is very much different from the role of financial creditors. Financial creditors get a seat, get a say, and get a vote in the CUC meetings. However, that is not the case with operational creditors. They do not have any voting rights when it comes to approval of the plan or other decision making of the CUC. And in such scenarios, they might feel the sense of exclusion, that what if our rights are not provided? And generally, operational creditors are also unsecured in nature. And even if the company slips into liquidation, they will get very, very little value. So this is one of the major issues with operational credit, that they feel left out and they feel like they will not be able to recover anything out of the corporate debt. So what kind of hostility does operational creditors create? They kind of keep on filing applications before NCLT to delay the process or to deviate or to create unnecessary hindrance. So, but once again, because they have no say or no voting rights in the CUC meetings, their their say ultimately has no relevance at all. At max, it is to be ensured that the resolution plan provides for the payment of operational creditors and uh, to at least that much amount which they would otherwise get when the company slips into liquidation. But that is the prerequisites for a correct resolution plan for the purpose of approval of COC and NCLT. But as respect to that, if they will get higher returns or if they will have to suffer slight haircuts, that is not something which can be confirmed, and that is the reason why operational creditors also become hostile. That first of all, feeling of being left out, perception of unfair treatment, and desperation of recovery of the amount that they had given to they had to recover. They have to recover from the operational creditor. Next is the case with
Actually, in
respect.
the case of operational creditor, there is one instance where there was a warehouse and the corporate debtor's equipment was stored in the warehouse. So this person never, I mean, he was hostile in terms of, not allowing the corporate debtor teams to access the warehouse equipment and, take control of certain items. So his demand was that even pre-CRP dues be paid out.
Right, the
So, and
electricity
he
bills
used to
which I
use,
was trying to find. Yeah. Yes, sir.
yeah, he used to, try this in a way that, whatever his money is owed, he can get it. But then, of course, we had to put Section 19. He filed an appeal and all that. But ultimately, we took control of the equipment from the warehouse, got access, and emptied it. But yeah, I mean, this is the way, many times things happen.
Right, and also in case of essential supplies versus critical supplies, because essential supply is something that cannot be paused or stopped when the company is into CIRP. So sometimes operational creditors also become reluctant in providing the essential supplies. So that is again one of the kind of hindrances that operational creditors might create in the CIRP process.
Because Neha, here we also need to see as to whether at all the supplies are essential or are for fueling the business of the company. Sometimes what happens is I need water to survive. So to the extent I need water to survive, that is the essential supply and I need it for it. But the moment I'm taking that much of water and again I'm supplying it towards a business of the company, or that I'm making hydroelectricity out of that water, so that is no more the essential supplies of the company. That crosses the limit of essential supplies. So essential supply you cannot stop, but you cannot at the same time ask for something which requires for the continuation of business. That is no more the essential supply. So this bifurcation between essential supplies and supplies
Essentials,
for the business of the company, this
the,
requires attention.
the term of essential supply is also I need to understand. The water, electricity, and telecommunication for keep the unit as a going concern are considered as the essential supplies. And one more thing, they have added that anything which keep the unit as a going concern is considered to be essential supply.
Absolutely, absolutely, sir.
So to keep the unit as a going concern, you may consider anything. See, I need to keep my production, keep the unit going concern. I need raw material. I need labor, etc. That kind of thing also considered as essential supply. What in that case RP should do? See, operation data will not serve you because their past dues are not clearing. They will not provide them new material. That is what their take on this after going into the CIR. So to keep the unit as going concern, what RP should do, whether that should be considered essential supply or not.
So here again, one needs to understand as to the extent the requirement is for the survival, for the bare minimum survival, or for keeping the corporate debtors going concern. For that bare minimum survival, till that extent it is essential. But the moment it requires for the running the business of the company, for gaining some extra advantages, that is no more essential supplies.
Ma'am, going concern itself cover the running of the business of the company.
Now, sir, the going concern that you are pitching about will no more be required, because as you also know that now the proposal is to remove this requirement of going concern sale altogether from liquidation stage. So now either to survive during CIRP, or once you slip into the liquidation, then there is no more going concern sale. No more going concern sale will be there. As of now, it is in proposal stage, but subsequently when the proposal will be e-gazetted, then this option to sell by way of going concern sale will no more be there. But yes, as you said that one needs to understand as to whether at all, when at what stage I'm saying it as a going concern. So for keeping the status of the corporate debtor as going concern, if I need that supply, if I need that particular part, so that should also be treated as essential supply and should not be excluded from the purview of essential supplies. So one needs to demonstrate that part, that this is required for the survival of the company till then. So like the employees, like I'm just giving you some example, like the employees. There are several employees in the company, but you need not need all the employees when the company slips into the liquidation. You need only bare minimum employees who are required to just switch on the plug of the plant, to see if at all the plant is running, to see if the machines are in the position. So it is not that you have to run the machine, you have to see the production is going on, but you have to see that the machines, etc., are in a running position.
How can I justify that production running the production is not my responsibility?
So this is
running the production is my responsibility.
No, actually, I have a view here. In my case, in one of the cases, the moment that this cooperator went into insolvency, the private electricity provider cut off electricity, and that company was running induction furnaces, okay, which are running on electricity. Now that becomes so. This was one of the earliest judgments where the NCLT, after a lot of deliberations and this thing, the power company also came to the NCLT. So they said that we have a lot of dues of previous pre-CRP which are there. So we will not give supply until it is cleared. We said this induction furnace, if it doesn't run, we don't have a going concern. So at least NCLT then suggested a via media. They said since it is a going concern, essential electricity supply, you should pay. So they ordered us as corporate debtor to pay for the electricity dues, keeping at least 1 month credit. So we had asked for 3 months credit for the supply, because ultimately, production will lead to sales and then of course recovery. So that takes time. So, but at least they come up with this thing saying that 30 or 45 days credit you take, but you pay on schedule, so that the company can supply power. So with that, the power supply was restored. And in any case, now it is a case law that if there is a essential supply which is required, you have to pay the dues at least to the extent that are required during CRP. Pre-CRP, you need not pay. But during CRP, whatever dues are there, you should pay Otherwise, the service provider is entitled to cut the supply.
That is ruling. In fact, there is a IBBI's discussion paper as well, sir. If you have seen discussion paper dated 6th of February 2025, wherein IBBI has clarified as to what will construe the essential supplies during CIRP. So there IBBI has said that essential supply, you need to see that there are 4 factors. One is electricity, second one is water, then telecommunication, and fourth one is IT services. And there the IBBI has said that you need to see that the extent these are not a direct input to the output produced or supplied by the corporate debtor, these are these are essential supplies. However, the moment you see that these are the input, these are the direct input, and based on this you are producing output, in that case it will no more be treated as essential supply. This is the discussion paper dated 6th of February 2025 by IBBI.
Correct. Actually, if there's a factory and you have certain lights which are there for security in the night, that would be essential supply for employees to function in the plant. That is essential supply. But if it is a supply for induction furnace, that is not essential supply.
Like you are giving the example of induction, sir. So the illustration that IBBI has given was of electricity only. So it was mentioned that electricity is supplied to corporate debtor for maintaining basic facilities to upkeep
Correct.
lightning, power, computer, etc. This will constitute as essential supply. But the moment the corporate debtor operates the manufacturing facility or high voltage electricity supply is requiring for the machineries, etc. So that is no more the essential supply. So that becomes the
Correct.
input that you are giving for the output production, and that will not be essential supply. In that case, you are required to make payment. And if you are not making payment, then they have right to cut it off. You cannot say that no, you cannot cut off these kind of supplies during moratorium, since moratorium is going on. So bare minimum survival thing which is required, only that will constitute essential supply, and that services cannot be interrupted during moratorium. Yes, Neha, please continue.
Right, ma'am. So, after operational criteria, next we are moving to the ex-workman and ex-employee, how they turn hostile and what kind of hindrances they create. So, for workman and employee, because if the corporate debtor slips into CIRP, their livelihood is also at stake. Because workmen belongs to the weaker section of the society, their livelihood depends upon the daily wage that they are getting. So, they become really hostile. They might turn really hostile in such scenario because everything that they have will come to stake. Their daily bread will come into stake once the corporate debtor, once they're not able to realize their dues from the corporate debtor. And therefore, some of the cases that we have listed down, that first is the job loss and uncertainty. Second is unpaid dues and benefits. When it comes to the unpaid dues of the workmen, there are 3 classifications. First is the dues pertaining to 24 months preceding the liquidation commencement date. Second is dues over and above 24 months. And third is the statutory dues, which includes gratuity, pension fund, provident fund. Fourth category can also be created out of the voluntary funds which the corporator had kept aside for for the benefit of its workmen. So generally what happens in most of the liquidation cases, what we have observed is the full payment up to second layer of the waterfall is even not satisfied. That is to say, workmen are not even able to realize past 24 months dues. So this becomes a very significant ground for them to turn hostile and thereby creating hindrances in the way of the resolution professional or the liquidator. Next is the perception of unfair treatment, because once again, workmen say has no say in the COC meetings or in the SSC meetings per se. Therefore, this could potentially be one of the reasons, and because they do not even have any representation as such, basically decision-making representation in the COC. So that is another reason why workmen or employee might turn hostile, and desperation and economic vulnerability, because as I mentioned that workmen belongs to the weaker section of the society, their entire livelihood comes to stake once a company slips into IBC. As regards the hindrances which which the workmen or the employees might create is because there is no information per se that we want from the workmen. So they create hindrances by way of sending goons against the resolution professional, or filing frivolous applications before NCLT. In several of the matters, workmen have filed a series of applications demanding series of benefits from the cooperative. And the problem here arises because workmen are not generally aware of the law about IBC. So that again becomes a ground for them to create hindrance. And in several of the cases, what we have observed is that workmen file application at different forums like labor court, consumer court, NCLT, wherever they find a way, they file an application. So this again delays the process because the resolution profession or the liquidator needs to look into all of these cases and not be restricted to the NCLT proceedings. Although the law in this regard says that NCLT is the sole forum for the purpose of dealing with the IBC matters. However, creation of such cases again delays the proceedings, and as it is rightly put up in case of IBC matters, the more the delay, the more is the depletion in the value of the assets. So this is.
In fact, some of the cases we have also seen these things as well, that the cases were initiated by the ex-workmen much prior to commencement of CIRP, for which no records is available, for which since now there are no ex-management officials, ex-officials of the company, or the officials who were there may not be there at the time of commencement of liquidation or CIRP process. So there is no record at all with anybody. But that process is continuing before labor court, before other forums, etc. And now that particular labor or that particular workman has also filed a claim before the liquidator. And liquidator is required to verify that claim. So while verification, what liquidator will do, liquidator will mention that this is a disputed claim. So the moment you are not accepting their claim, they will file a claim, they will file an application before NCLT that look here, the liquidator has not accepted my claim, or look here, the resolution profession has not accepted my claim. They have written this disputed claim. So they have not accepted my claim. And till the time you are not verifying that claim, till the time you are not accepting the claim, then you are not able to pay any obligations towards that claim as well. So what happens is, and the moment you are approaching NCLT, NCLT will say, how can I decide a matter which is pending before High Court? How can I decide a matter which is pending before Civil Court? I don't have that jurisdiction to decide those cases. Now there is no way to go. So I don't have the papers. I cannot pursue the matter before the respective court where the matter was filed. I cannot ask NCLT to take the note of the cases which are pending before the High Court and accordingly pass the order. So sometimes these kinds of matter also creates hindrance in the process, in the CRV process or liquidation process, as the case may be. And the more thing is about when it comes to workmen or employees, it becomes difficult to make them understand as to what should be done and how this process run. What is this IBC all about? It is not a general law. It is not about the law for which you'll just file the case and that's it. So there are provisions, there are particular priority provided. I can pay out of that priority only. They will say that my gratuity was pending. The ex-promoter has not provided me the gratuity. Now you pay the gratuity. Now liquidator or CIR or the resolution professional, as the case may be, they need to see if at all there was any fund created or not, whether there was any money put in the fund or not. Now, if there is a fund, whether the fund is sufficient to make payment to all the workmen or all the employees of the companies or not, or if there is any shortfall. If there is any shortfall, then how that shortfall will be met? Whether I need to pay that shortfall out of the liquidation estate or what? Or I need to make payment with the bare minimum amount which is pending in that particular amount. Similarly, when it comes to these cases, like some of the employees are no more there, then legal heirs have come to the liquidator or come to the RPs with respect to the claims of the ex-employees of the company. Then who will verify the data as to why at all that particular workman was left the company, or why at all that particular workman was not paid the gratuity amount, etc. at that point of time. So when it comes to issues connected with the workmen, it becomes very, very difficult for the liquidator or for the resolution professional to determine the respective rights. And because this is a very sensitive area of entire IBC process, you cannot just take a decision with respect to the claim. So you have to be very, very cautious when it comes to treating workmen, when it comes to making payment towards the dues of workmen. So you need to see the entire background, you need to see the entire details, you need to see the HR documents, etc., as to what was the record of the employee, at what point of time that employee was disassociated with the company, what was the reason for which the workman was not associated with the company, at what point of time the workman was not associated with the company, whether that is falling much before the date of commencement of CIRP, such that the liquidator or the RP is not bound to make payment to that particular employee. The employee which has left the company much prior to commencement of liquidation, that employee cannot come and ask for his payment or his 12 months or 24 months payment, because that employee was no more there when the company went into liquidation. So there are several these kinds of small little cases which may create hindrances when it comes to CIRP or liquidation process, and particularly for this workman, because the workman section of the entire this priority waterfall mechanism which is provided is very sensitive and requires utmost diligence, utmost care by the respective resolution professional or liquidator, as the case may be, to deal with.
And one such scenario also arise wherein the workmen are coming to the liquidator with the decrees that they have got from the labor courts. Because
so several labor courts while liquidator has given representation, but it has also been seen that the labor courts passes the order without giving the any leverage to this initiation of CIRP process or liquidation process. So the labor courts have passed the order in favor of the workman, and they have directed the liquidator to make payment. Sometimes it has also been seen that the liquidation process is about to end, and at that point of time, a workman is coming and saying that, see, I have a dues, and there are several penalties levied on you by the labor court. So now you are required to make payment. This award was passed in my favor. So at that point of time, when I'm left with no money at all, how can I make payment towards those dues, and how can I not abide by the order which is passed by one of the court which is at par or with the NCLT? How can I say that I'll not make payment? Can NCLT direct that you are not required to make payment for the order which was passed by labor court? So these are the dilemmas, these are the things that requires clarification. Well, nothing is provided in law so far, so we are required to depend upon the cases, similar kind of cases, as to how to deal with these kinds of situation. As I said, that IBC is completely based on the practical difficulties, practical concerns, varies from case to case. So one need to take hint from the other or similar cases as to how in that particular matter the claim was treated or the claim was accepted by the resolution professional or liquidator, as the case may be.
Right, ma'am. So this is about the ex-workmen and employees who might turn or who may turn hostile during the insolvency proceedings. Next, coming on the impact. Acha, before I move on to the impact, there is one more point which I would like to discuss here regarding situations where the state authorities might turn hostile. So one of the cases which we have seen in several of the matters is that, so let us consider a situation wherein the liquidation of a particular corporate debtor has started on, say, 1st of January 2020. And all the previous dues of all of the income tax department or other departments, instead of a due becomes a claim to the liquidation estate, which will be satisfied pursuant to the provisions of Section 53, which provides that government dues will be paid at fifth priority. So now what happens when the liquidator is filing the income tax return for all these years when the company is in liquidation, which in several of the cases results in refund of income tax paid. But then, because of this automated system at the back end of income tax department, all the refunds are adjusted against the past dues, which are no longer their dues, rather they become a claim on the liquidation estate. And pursuant to this arrangement, they are kind of claiming a priority over Section 53. Instead of the fifth priority, that is government dues, they are claiming a higher priority or rather the topmost priority before secured traders or workmen. In such scenario, what we have observed in one of the cases is that even after NCLT had directed the tax department to refund all this adjusted refunds against the past dues, that is the dues preceding the liquidation commencement date, even after clear-cut judgment of NCLT, state authorities have not refunded the amount to the liquidation estate. So even after multiple follow-ups, they kind of do not, pay off the required funds to the liquidation estate. So this also becomes one of the hindrances when it comes to tax department, that pursuant to the automated system, they adjust the amount which otherwise is not required to be adjusted. So this is about the potential hindrances or the hostility that a IB may suffer during liquidation or insolvency cases. Next, let us discuss about the impact of these actions on the insolvency proceedings. First and the foremost impact
What
is
about,
delayed process.
can I raise one question?
Yes, sir.
Have you gone through the situation where the ITC is to be recovered during liquidation period and generally department refused to refund that ITC?
So, sir, what happens in case of GST? So there is the income tax, the input tax credit that you're getting, you can adjust it against the forward charge that you're required to pay off.
No,
And in case of reverse charge, you actually have to make the payment. So even if you have a good amount in your ITC balance, that cannot be used against payment of the reverse charge, which generally applies in case of advocates' fees and other such expenses.
so how to get a refund of that ITC? ITC on fee of liquidator and all that. I generally department refuse to give it.
In general parlance, sir, we have also seen that this ITC generally get unrealized because we cannot use this ITC balance for the purpose of paying the GST and the reverse charge. So generally it just depletes away or is not realizable because GST department generally does not allow refund of the ITC.
I want to know, is there are there any case law or that so that we can pursue over this or go to tribunal, GST tribunal to get it
So
funded?
far, we have not come across any such cases, but we can surely look into it because in almost every liquidation case, this is a common issue. So far, we have not come across any such case, sir, where the refund of ITC was also allowed by the department.
No, I have one case in that they refused to give it, but they said, okay, you must give it, but you have to go to tribunal for that. So, do you come
So
across
was
any cases where tribunal have granted refund of ITC?
So far, we have not come across any such cases, but we can surely look into it if there at all been any case as such where tribunal allowed refund of the ITC amount. So next is with respect to the threats to the insolvency proceedings pursuant to the hostile stakeholders. First is the delayed processes because the more the number of applications which are pending, the more time it takes for the purpose of completion of the process because the adjudicating authorities are already too burdened with the number of cases pending. Second is the increased cost. Increased cost in several manners. First is for pursuing the litigation which different stakeholders have preferred for different authorities. Second is the cost, like we were discussing some time back, that workmen come with the decrees wanting the liquidator to pay off the money pertaining to the period which was much prior to the liquidation commencement date in total. So this kind of situation also will lead to increase in the cost. And third is obviously the more time it takes for completion of the process, the more depletion it causes to the asset. Therefore, erosion of asset value is another such outcome of the hostility and challenges in COC functioning because the COC members are not in concurrence with the decision making of each other. They are not able to approve a particular plan, which is eventually leading to liquidation. Liquidation results in significant depletion in the value of the assets of the corporate debtor. So these are the, kind of impact which hostility brings in and hampered liquidation, reduced stakeholder returns because the more value of the asset depletes, the less will be the recovery, and eventually very less amount will the stakeholders eventually be able to realize. And given the kind of pressurizing situation IPs generally get into pursuant to these hindrances, it also impacts their effectiveness. Like in some of the cases which I was discussing some time back, the ex-management or the ex-promoters become so hostile that they had sent goons against the resolution professional. And eventually RP had to take help of the police of that particular area. So this kind of hostility also creates a mental trauma for the insolvency professional and eventually leads to the damage to their effectiveness. So these are some of the impacts and the areas which we had thought of discussing. At this stage, if any of the participants would like to also share their experiences or would like to add to the discussion that we till now had. Barsha ma'am, if you would like to add anything at this stage.
Neha, you have correctly mentioned regarding the threat to the insolvency process, like impeding the resolution plan approval, then hampering the liquidation process, then damaging the IP's effectiveness. So all of these are basically, you know what, like these are the issues because of which the IBC process is not getting completed within the given timeline, as in, is unnecessarily getting extended. On one hand, you know, just filing the application before NCLT and saying that we have taken appropriate steps to conclude the process is not the ultimate solution, because we all know that NCLT is quite burdened with other cases as well, with IBC cases as well. And in one particular IBC case which is initiated, there are several connected applications as well, which keeps on tagging along with the main case, and NCLT hardly gets time to listen and to hear all the cases in detail. So merely filing the application before NCLT will not help. We need to see the best practical solution otherwise as well, if at all that is available. Then of course the other civil process are also available, so we can also move with respect to, you know, to the extent it is required to get interruption of police etc for taking the proper hold of assets of the corporate debtor, or to ask the respective ex-management, ex-officials of the company to cooperate, etc. So we are also required to do that. So the entire this hostility is about what are the things which are creating hindrances when it comes to completion of the process. So who all create hindrances and what kind of hindrances are generally being created, how NCLT has resolved those issues, what are the other modes, other ways available for the insolvency professionals to get rid of these kinds of issues, and how one can resolve these kinds of issues, whether at all cases or whether at all the resolution taking in one particular case can help in other cases as well or not. So these are the things which requires consideration, which requires attention of the insolvency professionals, which also requires attention of all the stakeholders, because IBC is not just a process which requires to be run by the insolvency professional. It is a process for all. So insolvency professional is generally a mediator, is a person who's been appointed by the court as an officer to realize the assets, to pay off the dues in terms of the law which is provided in law. At the same time, it is the duty of all the stakeholders to give necessary cooperation to these insolvency professional, so that the insolvency professional can complete its duty in time and in line with the law. This is, I think, is all about this particular topic. If there is anything, any concerns that requires discussion, or anybody has any kind of statement to make or anything with respect that requires discussion at this stage, given that there are several IPs available, so we can discuss that part, or else we can wrap up with the session here.
In one of my cases, my name is Kashi Vishwanathan Shivaraman.
Yes, sir.
In one of my cases with regard to section 19.2, the NCLT bench said that since the resolution plan has come out, I am disposing of this application without even looking into the merits of the case. The 19.2 application was filed. And in one of the hearings, they said that the resolution plan has come out. So all document, whatever the information is available has been obtained by the resolution applicant. So I'm disposing of that case.
Ideally, this should
This is
not
one
have
of,
happened, sir, because if you see the provision, particularly with respect to
I
liquidation, it
understand,
says
ma'am,
that
but one thing is how can you go and ask the judge, how can you pass such order? Right? I cannot
that
even
is
go to,
again, yes, that is again is true, because the role of insolvency professional is limited. What you are required to do is that when you have not got the cooperation, you can file Section 19 application. For the cases or for the matters which drag the company into this situation, you can file the avoidance transaction application. But you cannot go beyond what NCLT has directed. If at all you see that that is not in the interest of the stakeholders, then of course you have this resort to go to the higher authority, to the NCLAT, to the Supreme Court. If at all you think that that is not the order which has been passed by NCLT is not in line with the or is not in interest of the other stakeholders. However, where that is not such thing, or if the circumstances is not such and NCLT has taken a call at that time, of course, being a professional appointed by court, you cannot go beyond what has been directed by the court. So you have to abide by the respective court.
let me explain you one case. The RP can go against the order of NCLT unless and until there is something which is against against the RP. For example, he cannot pursue a case where there is some strictures, when there is no strictures passed and the orders are made, and he cannot go beyond that. He cannot go to NCLAT. For example, if there is an order passed by NCLT and if it is not affecting the RP in any way, then he cannot go to the higher forum for appearance. That is what is the thing which I have learned from this case of handling NCLT cases, where because of the Supreme Court ruling which has come out in this case, when the RP is not aggrieved of the order, he cannot pursue the case beyond the level of adjudication. That is what is
The thing is such
opinion
that,
given by the
so we
given
need
by
to
my
understand one thing
advisors.
here, that RP is not acting for his personal interest. RP is
That is
acting
right.
for the interest of the stakeholders. So if RP is taking any particular call that I need to initiate an application, that call has to be supported by the respective stakeholders for whom I am fighting. So I am fighting for the stakeholders. If stakeholders are not there, if the creditors are not there, why will I file an application? The moment I am filing the application, I have to be there till the time that process or that application is getting resolved. And we all know that how much time it is taking before the NCLT, NCLAT or the other forums to dispose of a particular case. So I need to be backed up by the respective creditors for whom I am fighting. If those creditors agree and if they say that no, you need to go to the higher authority or higher forum for the purpose of for our stake, because the order which has been passed by NCLT is not in line with justice or is not in line with the interest of the majority of creditors, then the RP is duty bound to file the application on behalf of the creditors before the respective forum. So it is not, RP is not, why will RP will get prejudiced by the order? RP has nothing to do, no lena dena with the matter. Why will RP do? RP is getting his fees.
That is what I'm saying, ma'am. For example, see, when there is an order which affects the functioning of the corporate debtor, you are saying that you are responsible for the corporate debtor. And if the order comes in such a fashion that it affects, you are not affected in any manner, that is what they say, then what will you do? You are saying that you are responsible for the corporate debtor. But when the order comes,
see,
when the order comes,
it is not again about the order which is against the corporate debtor. We need to see the order which has been passed by authority, whether that order is prejudicing the interest of creditors or not.
That is what the creditors have gone against that case. They have filed their application. That is fine. But one thing is what the creditors feel is, why are you not going? You are not going against the order. That is the question being asked by the COC. See, I am not aggrieved by the order, right?
Absolutely,
Because I am an
absolutely.
RP.
To the extent RP is not aggrieved by the order, why will RP pursue any case before any forum?
Pursue the matter. Now the question arises, the COC asked the question, why are you not pursuing the order? Because you are supposed to handle it. But that of course, I could educate my COC and say that you file your application, you get your order done. I have only limited grounds to appear. I am aggrieved on certain limited grounds where I had to go for an appeal. I went for an appeal. But I cannot go against the order or stricture of the NCLT.
Because
That is what I
COC
said.
also needs to see, sir, that the moment you are starting a fresh case or the moment you are filing an application before higher forum, that will require money from the state itself. That will be, there will be pinch on the pocket of the respective creditors only, because ultimately you will need fund to start the application, fund to avoid, fund to have one senior advocate or junior advocate as the case may be. So that fees will be there, and who will pay the fees? Fees will not be paid by the
That
RP.
is what is the
Fees has to
thing.
be paid by the COCs only.
Anyway, of course, this is one of the things. In 19.2 application, in one of my cases, the order came like this. I could not do anything more than that. Just kept quiet because the resolution plan has come. So fine, gone.
Understood, sir. Is there
Barsha,
any? Yes, sir.
Barsha, I have one question.
Yes, sir.
If suppose 19.2, you are not getting cooperation, you have not got any information from the promoters or the existing management. Okay, it's a RP responsibility to file a 19.2 application. So on what basis? Because he have no informations on the promoters or directors or anything. The premises are rented, closed. You are not getting any informations. It's the private limited company and others. So as soon as you file, what max you can do? You can file 19.2. Okay, and 19.2 also it is pending, and your plan is approved and everything is done. Right now, sir was saying, then NCLT is saying that because the plan has been approved, they know no locus standi of RP for 19.2 and they are closing. So in that case, suppose your plan has been approved by the NCLT and they have passed the order, and the new resolution applicant have already taken over the company, and now he's saying, I don't want to do all these things. I don't want to pay expense and all these things. So you don't appear, and again, where you will appear before the NCLT for each 19.2 application, whereas next dates are coming up and no one bothered. Even COC is not bothered. New RA is not bothered. Existing management, as usual, they are not bothered. Only RP, because he has filed the case, he have to run around the NCLT and try to get the order. So what is the at that time? What do you think? What RP should do? Whether he should withdraw with the permission of all the stakeholders, or whether he will just leave it?
So here we
Because
need to understand one thing. The reason why we filed this application under 19.2 was for cooperation, because the ultimate promoters or the ex-management of the company have not provided the cooperation. That is why we have filed this application, because until unless we'll get the cooperation, we will not get the details of the assets that are required to be realized, and accordingly, how will we proceed ahead with the further task? So on one hand, we are saying that the particular persons have not provided cooperation, because of which I have filed this particular application. The moment I have sold the assets, the moment I have realized the assets, the moment I have received the resolution plan, and then accordingly the claim of the respective creditors will be taken care of. Now claiming that there was no cooperation does not hold good at this stage. So the moment you are filing the application for approval of resolution plan and the final hearing will be held, at that time, ideally, practically, in my view, what is required to be done is this particular fact that an application under 19.2 is also pending before the adjudicating authority should also brought before the attention of the adjudicating authority, that this particular matter is still pending. If bench feels so, then bench may pass necessary directions to the respective SFIOs or respective officers to do the needful, to start the proceeding against the ex-management or to punish them, or the bench may take call to punish them as to why they have not cooperated and because of which the process has taken so much of time. But when the resolution plan is already received and the concerns and the claims of the respective claimant have already been taken care of, then RP has no role to play after that. I am an officer and I am been appointed for a particular duty to discharge. I have been appointed to realize the assets. I have been provided with a duty to make payment to the respective claimants. So all those tasks are done. Now, why at all I'll stick with the process for long, merely to punish them? So punishing is a task of NCLT. That is brought before the NCLT that the only thing is which is pending is the punishment. If NCLT thinks so that they requires or they should be punished, NCLT may pass direction. Otherwise, now that the process is getting concluded, now just engaging me particularly for the purpose of 19.2 will not be in my favor, because now who will pay my fees? Who will pay the fees of the respective professionals to whom I'm going to appoint? Because creditors have got their dues. We need to see these things from the practical aspects, sir. That
Correct. So,
ultimately,
coming on your point, ma'am, just
yes.
one more question. Suppose the plan has been approved, 2 years already done, closed, and RP is not being paid. RP is not being paid by the a successful RA, even the COC or anyone. No one is ready to pay, na? And this case is 19.2 is still pending because no one is appearing. And when I sold this company as a resolution plan, at that time, suppose a resolution plan is saying all the litigations and everything will be taken care by the successful resolution applicant. Okay, now the successful resolution applicant says no, I don't want to do all these past events. I'm happy with whatever I am doing, and I'm go ahead with all the things which I have received. So 92 is should be closed off, or RP should withdraw. RP is not ready to withdraw. He is saying let NCLT part the necessary.
No, ma'am. I also agree with the point. Suppose when the plan is received by the relation professional, and the plan is also approved by the COC, that's okay. But why should I take back my non-cooperation application? In future, if anything which is critical, even after receiving the plan is come to the notice of the RP, that should be reported to the RA. This is what the law says. And it is the responsibility of the corporate to provide all the document. Let it be before concluding the final approval by the AA. So in my case, the 92 shall not be withdrawn even if the plan is approved by the COC.
Sir, in your question only, I'm asking this particular question that you have asked documents, or that non-cooperation was for what?
Yes.
What was the reason for that non-cooperation?
For assessing, for giving the assess to the providing the me the assess. Any reason 19
That was for the so that you can
number
realize the
number
asset.
and
So that
number
you
of
can
reason.
realize the asset. Now that you have realized the asset.
I will realize that once the double A pass the order, not by
No,
the
I do
COC.
understand your concern, sir. So again, I'm coming
Yes.
to your point only, that you are saying that at that time they have not provided cooperation, hence you had started this process. So what is the ultimate outcome of that 92 application? The ultimate outcome is to punish them, that why they have not provided the cooperation. What else do you expect from the NCLT? What will NCLT do? That non-cooperation was for not providing the information. Now that information is of no relevance. Now if at all they will provide the information, that holds no relevance, because you have already realized the assets. You have already sold the assets.
Try to understand, ma'am. Try to understand. Being a rational professional, my responsibility is to get the plan, and plan must be viable. As far as my documents are concerned, the plan is viable on the basis of document which I have with me. But maybe there are some documentation or some kind of things which are yet in the control of the corporate debtor or the promoter of the corporate, which they are not providing. Ultimately, after approving the plan, the AA, if it feels that that particular information is supposed to be with the SRA at the time of CIRP, then what should I do? Then
Sir, who will require the information? The information connected to the assets of the company. Who will require those information?
SRA.
And SRA, by just presenting the resolution plan, is it done with his job? Or SRA is
No,
also required to implement the plan and see what all
SRE
documents will be
is
required by
supposed to
SRA.
implement the plan. But if he requires some critical documents,
For how long you are responsible for the SRA to provide the documents?
for
As
how
a
long, sorry?
resolution professional,
At
there must be
least-
some
at least-
timeline
at-
on you as well to
No,
provide the documents of support to the SRA. How long you will be
that's what I'm
associated?
saying. At least in conclusion, from the AA, I'm supposed to give the information to the SRA till the plan is approved by AA, not by the COC.
No, I do agree with you, sir. Then again, the concern is same only that the SRA is sitting there. SRA is supposed to implement, and you are required to support the SRA to see the SRA implements the plan.
At that time I am not responsible. After once the AA approve, that's the monitoring committee's decision. What they want to do. But till conclusion of the plan, approval by the AA, if any kind of information which I feel is supposed to be with me or with the SRA, that I think the 19.2 shall be continue, not by the approval of the COC, but till approval of the AA. Let the AA decide. They should see the
First thing
ultimately
is
plan
that
is
only
supposed to
that
be.
the moment you receive a resolution plan, at the same time you are also required to enter into the possession transferring agreement, etc. with the SRA. That SRA is satisfied with the documents that you have provided, and you have provided all the sufficient information which were required by the SRA.
That thing should be done after approval of AA, not the approval of the COC. The documentation handover, all these things shall be done after approval of AA, not by the COC approval.
Not by the COC. I'm not saying by the COC. COC after AA, after adjudicating authority will approve the plan, then implementation stage will start. During implementation stage as well.
Implementation is not my concern. Implementation is monitoring committee concern, not my concern.
No, sir. Of course, the moment, if say suppose the implementation process starts and the respective persons and the respective SRA will require certain documents or information or support from your end, can you say that no, I am no more responsible?
That's what I'm saying. Why should I withdraw 19.2? That's what I'm saying. Why 19 should be
That is why
withdrawn?
you have made 92 and 19.2 is up to NCLT to decide.
Yes.
Now, so you have to bring before the NCLT. That is what I'm saying, that you need to bring before the NCLT that this particular application is also pending to decide.
Obviously, the plan should be approved and also consider the 19.2 along with the approval of the plan. That's what I'm saying. Not before
Absolutely. So this is upon NCLT to decide.
Yes, that's only the COC approved the plan. I am not supposed to take back my 19.2.
No, I am not talking about taking it back. You are not required to take back the application which was filed, because taking back the application is taking back the allegation. I'm saying that they had provided cooperation. It is not about taking back the application.
You mentioned that I am not supposed to punish the CD. I am not punishing the CD. I am supporting the SRA and supporting the process only. RB is supposed to not punish anybody. That's fundamentally
clear. It is not about taking back the application which you had filed, but it is about bringing this fact before the NCLT that this particular application requires your attention, because now the process is about to get concluded. So conclude this particular matter as well.
This should be the step. I agree with you, ma'am. Thank you.
Is there any other cases, any other concerns that requires discussion? I think, Neha, then we can conclude. Thank you, everyone. Thank you for the active participation. Anjali ji, if you are there, then we can conclude.
Yes, ma'am. Shall we conclude the session?
Yes, we can conclude the session now.
Okay. Thanks very much, Barsha ma'am. Thank you very much, Neha ma'am, for such an interactive and good session. Thank you very much for sharing your experience and learning with the participants. Ma'am, you are requested to please share the material shared in the workshop.
Yes, Neha will share that. Thank you. Thank you, everyone. Thank you so much.